Good morning, all. This hearing is in the matter of CFI 050-2025 and CFI 051-2025 and is being held by way of video conference before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant in CFI 50-2025 and CFI 51-2025 is represented by Quinn Emmanuel Urquhart and Sullivan. Lead counsel is Mr. Tom Montague-Smith, KC. The defendants in both CFI 50-2025 and CFI 51-2025 have elected not to make representations at today's hearing. Thank you, Your Honor.
All right, thank you. I just confirm, please, that none of the defendants or anybody representing them is online.
They are online.
They are.
Yes, so you've got Mr. Whitehead from Hamdan Al-Shamsi, who is the law firm representing Byju Raveendran. And you also have Mr. McNutt, who you may recall appeared last time. A few moments before Your Honour joined, Mr. Whitehead said that they do not have counsel instructed on behalf of Mr. Byju Raveendran for today, but they are here to take notes of what happened. Mr. McNutt has since left the call, I think, but there we are. He was here for a while.
Well, I'll first of all go to Mr. Whitehead. Mr. Whitehead, now you and your firm are representing Mr. Byju Raveendran in these proceedings. Is that correct?
Correct, Your Honour. We're still on record,
yes.
But as Mr. Montague-Smith quite rightly points out, we don't have instructions for this hearing in terms of representation.
Yes. So you don't intend to make any submissions today?
Correct.
All right. Secondly, is it correct you do not represent Mr. Byju Raveendran nor Ms. Gokulnath? Is that correct?
That's correct, yes. All
right. So is it correct that there is nobody online who represents Mr. Byju Raveendran or Ms. Gokulnath?
I think that's right. I think, like Mr. Montague-Smith said, Mr. McNutt was online before, but it appears he's no longer here. So I think that would be correct. But again, other than other people, I'm not sure. There's certain people I don't know, but that's my understanding, yes.
All right. Well, I have given an adequate opportunity for anybody representing Mr. Byju Raveendran or Ms. Gokulnath to make themselves known. They have not. From that, I proceed on the basis that Mr. Byju Raveendran and Ms. Gokulnath have elected not to make any representations at this hearing.
Your Honour may have seen, I don't know whether you have, there's letters, one from each of them.
I have. There's been something of a flurry of documents, which I have skim read, I would say, not with the detail probably I might need to in due course, but I have skim read them, and they are to, so far as Mr. Byju Raveendran and Ms. Gokulnath are concerned, I have taken them to be to the effect that they are not appearing today, that they have not instructed any counsel or legal representative to appear for them today, and subject to what Mr. Montague-Smith may have to say, it seems to me that so far as the applications brought by those defendants, that is the defendants in CIF 050 of 2025, being application CFI 050 20254, the defendant's application for a discharge of the freezing order and or for fortification of the cross undertaking by the claimant, they have in effect chosen to abandon or not, or at least not prosecute those applications, although I might need to read it more carefully because they seem to at the same time seek to reserve rights in some way. So that might be a matter, Mr. Montague-Smith, in due course, I'll ask you to address me on. So I think we've got through the position of representation, and I think we're ready for you, Mr. Montague-Smith, to present your case or applications in such order as you see fit, but perhaps you might tell me that at the outset.
Yeah, of course. Thank you very much. All right. As I understand it, the position of Byju Raveendran I don't know whether you saw the letter that came in from him, and that's towards the end of the. I'm grateful.
As I say, I've skim read it, and it might it might deserve a more careful reading at a later time, but I have skim read it.
We don't really understand it,
right.
and what it says, it's at bundle page 11,317, but essentially they take the position that there are no issues that arise because, as I understand it, they say that your Honour's decision on jurisdiction and collateral use has prejudged the issues or some of the issues. We see nothing in that allegation, and we had wondered whether that amounted to some form of concession, but then they go on by saying there are no issues, but then they go on to reserve their right to appeal. So it does appear that they are not conceding our application to continue. They're not withdrawing, as far as we can see, their application, which they made last time, to set aside. And obviously there's the other application that we make, which is for and then they also make an application for alternative service. So it seems to me, well, to set aside the order that you made in relation to alternative service. I do apologise. And so it seems to me that the chances are Your Excellency Your Honour is going to have to issue a judgment in relation to this.
Yes.
And therefore, the best approach today would be for me to take you through what we say, in relatively speedy form, what we say about each of the issues. So you've got what you need from us to help you write that judgment. And I would
hope just stopping you there, Mr. Montague-Smith, emphasising that is that you give me what's going to help me to write that judgment. I'd invite you not to go too speedily through the matters.
Not too speedily. Understood. All right, that's very helpful. And I mean, I would hope at a reasonable pace, but without going too fast, that I would be able to get through that in about 2 hours. I would have thought, in relation to all the issues in relation to Mr. Byju Raveendran. That then leaves the position of Byju Raveendran and Divya Gokulnath. Now, as I've only myself seen those letters this morning about half an hour ago, but as I read them, on one view, one might read them as an application to adjourn these hearings because they say they should not go ahead. Why should they not go ahead? Because Your Excellency granted an order permitting Al-Tamimi from withdrawing from the case. They say that, again, the position is very curious because they say they opposed or would oppose that withdrawal. They also say that they have not paid Al-Tamimi, and they also say that they want to sue them. And also, Your Honour should know that Al-Tamimi remains on the record on shore for these parties. So quite what the position is very unclear. Well, apparently. Whether that's temporary or what, I simply don't know. I think the short answer to their application is that Your Excellency's order allowing Al-Tamimi to withdraw was made on the 10th of October. And here we are just over 6 weeks later, and they have not got alternative counsel, or maybe they don't have alternative counsel, given that we saw Mr. McNutt on the phone before Your Excellency joined the call. Yes. But one way or another, either they should have been able to get alternative counsel, or if actually genuinely they could not find alternative counsel, this case can't just sit around forever. And while it's difficult, litigants do represent themselves. So we do not consider that it comes anywhere near justifying any form of adjournment. And that's all I was going to say about
I think, Mr. Montague-Smith, so far as lack of legal representation is concerned, I note that they do not say that they have made any attempts to find legal counsel. It may be, of course, that is open to a number of possibilities. One, that they simply do not wish to. Alternatively, and I think it's alluded to in their letters, that perhaps they don't have the means to engage counsel. But if that is intended, they don't suggest that a delay or postponement will change the situation. So there is, the way I approach the matter is that there is no evidence before me, and it's not been put, that there should be, that anything has occurred either by way of attempts to obtain counsel or impediments on their attempts to obtain counsel, which will be changed by giving them more time. So that in those circumstances, my current view is that nothing would be served by adjourning the proceedings, and no grounds have been made out for that.
Thank you very much. All right. Well, I
It
will
does
say
raise
more.
one possibility, though,
Yes.
which you might want to come to. If you persuade me that I should make orders continuing the freezing orders, continuing the proprietary injunction against Mr. Byju and dismissing the discharge applications and the fortification application, security for costs application. It's a question, I suppose, whether I should leave open the chance for them to bring further applications. I suppose, so far as, in one sense, they can always make another application, and in that sense, perhaps there are not grounds for giving them, as it were, leave to make to apply on further notice for any of those things. And I suppose, if, depending on the outcome of those various applications, if the applications were dismissed and they seek either to appeal against them, well, of course, the appeal process would take care of that. Alternatively, if they make new applications, they would have to be considered and resolved at the time on the merits.
Yes, exactly.
When I say the merits, I don't mean the ignoring the fact that they've already been dismissed.
Yeah, quite. I think obviously, if and when those applications were made, we would characterise them as abusive.
Yes.
Unless something really has changed,
and that would have to be determined at the time.
Exactly, and so we would not invite Your Honour to make any particular order in relation to that. Just to update you, and I do apologise because you asked the question: is there anyone online who represents Byju Raveendran or Mrs. Golkanath? It looks like there are two people online from Mr. McNutt's law firm. Bruna Montero and Samia Afrin are online, and they appear to have Lazaref Labar email addresses.
Right.
So it's a shame when you asked the question that they didn't identify themselves, but there we are. They've now been identified.
All right. Well, Mr.
Right.
Montague-Smith, I will proceed on the basis that they are present to hear what is happening, unless they choose to come online and tell me that's not correct. But I similarly proceed on the basis that they are not instructed and will not be making any submissions on behalf of those parties. But thank you
Yes,
for that
that's
information.
correct. Sorry, that is correct. We are only here for training purposes, just to hear. We are not
Yes.
here representing Mr. Byju and Ms. Divya. We are not.
Right.
It is the
Very
same
good.
case for me as well, sir.
All
And
right.
just for training purposes. Thank you.
Well, you are here to, let me just confirm that you are going to observe and hear what happens, and you will report that back to your principals. Is that correct?
Yes.
Yes. All right. Thank you. Yes, Mr. Montague-Smith, I think we can go back to you.
Thank you very much. All right, and that's so I will deal with that, the various applications and cross applications in relation to those two defendants. And again, your Honour indicates that perhaps they've abandoned or are not proceeding with their applications. I still need to persuade you of my continuation application.
Yes.
And again, it may just be more safer, I think, from my perspective anyway, just to go through that all. I would hope to be able to do that in about an hour and a quarter or an hour and a half. And so
well, in terms of, I'm sure we've all set aside the day, so take whatever time is helpful. Don't seek to unduly rush it.
Thank you. There's a hand up on one of the participants. I don't know whether you wish to hear from them.
Ah, is that Bruno Monteiro?
Correct.
Hi, yes, sorry. I have a question. Yes. It is my understanding this hearing is public, correct?
Yes, the hearing is public. Yes. Can I just ask though, Ms. Montero, that unless you're wishing to make representations, you turn your microphone off and don't intervene. Thank you. It's not a forum for you to ask questions. It's a serious court hearing.
Yes, thank you, Mr. Montague-Smith. Yes, Ms. Montero, that's correct.
Okay, thank you.
All right. Yes, Mr. Montague-Smith.
Thank you. All right. So just to remind you, I'm sure Your Excellency's read the papers, not all of them perhaps in the bundle, but has read.
I think they run into the.
I know.
It's over the 10,000 mark, I think, in pages, but I've done my best.
It's over the 11,000 pages,
11,
I think. But,
yes.
Yeah. So what you should have is in relation to Byju Raveendran, you should have my skeleton argument from last time.
Yes.
And then also Mr. Byju Raveendran's skeleton argument. And that should contain most of the argument that you needed to pre-read for this hearing. And I'll remind Your Excellency of the issues as we go. But essentially, we've got the cross applications for continuation and set aside of the proprietary order and the freezing orders.
Yes.
And you've heard Mr. Byju Raveendran's position, albeit some time ago now, and that's part heard. So I will respond. Then there are outstanding applications from Mr. Byju Raveendran for fortification and for security for costs. And then there's his application to set aside the alternative service order. That was put as part of the jurisdiction application, but I will deal with it briefly.
Yes, I must say it escaped me this time round. That's part of the alternative. Which application is it?
So it's an application to set aside the order for alternative service. Right. And so Your Excellency may recall that when we sought the ex parte freezing order and proprietary order, we asked you to grant an order for alternative service, permitting service by various means, including email. And one way or another, there is an application challenging that order discreetly. So I haven't planned to spend a huge amount of time on it, but I'll just give you my reasons when we get there for saying that you were right to grant that order. But that's the scope of it with Byju Raveendran. For Byju Raveendran and Divya Golkanath, we've got again the application to continue the freezing order against them and the cross application for discharge. We've got their application for fortification and possibly for security, and then there is a further disclosure application against them, which you may recall.
Yes.
You've decided effectively the Ryju Raveendran one, and
Yes.
we say for very similar reasons that Your Excellency granted that order, we seek disclosure. So I will start with your permission on the continuation and
Yes.
set aside.
Yes.
And what I propose to do here, having explained the application ex parte and Your Excellency having accepted it to that extent, what I propose to do here is focus on the points that are made by Mr. Ryju Raveendran at the last hearing and in his written and oral submissions that were made. And if we could start, please, if you've got access to the bundle, if we could go to page 462. And Your Excellency may recall that his grounds for set aside were set out in a statement of case, and there were two of them. One of them was about jurisdiction, and the other one was setting aside the proprietary injunction. And in this document, Mr. Raveendran raised quite a lot of points about the proprietary order. No points were taken on continuation of the freezing order. So in fact, there was no actual challenge to the freezing order continuation. And if we go to page 463, you see that paragraph 4, Mr. Ryju Raveendran stated that he reserved the right to separately seek discharge of the freezing order. Yes. But he has not actually, in fact, done that. So we had come last time to deal with the points that were made in this document. And then, of course, there was his skeleton argument, which he prepared and submitted for that hearing. And that argument, that skeleton, raised a host of new points. And some of the points, I think, in the application, and indeed some of the points in the skeleton argument, were dropped in the course of the hearing. So that it was a bit of a morass of points, but what I'll do is I'll try to deal with the application, picking up the points made in the skeleton at the same time, but starting really with the skeleton. I don't know whether you have the skeleton separately. That he had, or I can take you to the page in the bundle if it's easier, but it might be useful if you've got a copy.
I did have it, and then I've managed to close it. Bear with me for a short time, and I'll try and open it again. So this is the skeleton for the 31 July, 1 August hearing.
Correct.
Yes,
so
yes, I have that separately.
And so if we can start, please, at paragraph 29 of that.
Yes.
You'll see that essentially, sorry, I'm taking you to the wrong bit. I was supposed to take you now to a different document, which is my skeleton argument for last time, okay. Paragraph 29. And I don't know whether you've got that separately as well, because it's probably
again,
useful.
Bear with me for a minute. I'm going to open it again. So now this is your skeleton for, again, that same hearing.
Yes, the same hearing, and it should be the one in claim 051.
Yes.
And it should be return date. So it should be return date and jurisdiction challenge.
Yes, I have that.
Very grateful, thank you. And obviously, I won't address you on the jurisdiction elements, but if Your Excellency was to turn to page 6, paragraph 29, and just to remind you, what we had done was to go through the application document, go through the skeleton argument, and pick out all of the points and try to allocate them to what we felt was a logical structure. And so you've got all the references in the footnotes to where all the points come from, but we've allocated them to questions of jurisdiction, which are raised separately. So what Your Excellency has decided in relation to jurisdiction is jurisdiction over the claim for recognition and enforcement. But there is potentially, and we'll come on to it, it's not in fact a jurisdiction complaint, but what is described as a jurisdiction complaint in relation to the proprietary injunction itself. So the headings are going to be jurisdiction, serious issue to be tried, and we've identified 8 subgrounds there. Balance of convenience, full and frank disclosure. There were 3 grounds in the application, but about a dozen more appeared in the skeleton argument. So some have been dropped, so I'll run through those. And then there's the issue about cross-undertaking damages. And relatedly, but perhaps not quite the same, fortification. And then there is alternative service.
Yes.
So the jurisdiction objection starting there, if you've got the bundle open at page 463 and we go forward to page 464, please, that sets out the jurisdiction objection at paragraph 10 under the heading absence of jurisdiction to issue a proprietary injunction or enforce the US preliminary injunction. And when you look below it, Your Honour can see immediately that this is not in fact a jurisdiction objection, because what it does is it sets out and relies on the test for granting proprietary relief, so the substantive test, and then goes through each of the factors. It cites the case of LARMAG, and indeed it cites the 26th August 2019 judgment in that case. You'll see that at paragraph 10, and then in the footnote number 2. If you'd like to look at that case, I think the point that we'd make about that case is it's not about jurisdiction at all. Jurisdiction had been considered and decided in an earlier judgment. You can see that. I won't take you to it unless you'd like me to, and I'll say that quite a bit, Your Honour. And I'm not discouraging you from doing that.
No. If you tell me the point, and then I'll tell you if I want you to actually take me to it.
Perfect. Thank you very much. Just in case you change your mind subsequently, the references to the authorities bundle, page 420. And the point is that if you see paragraph 2 of that judgment, you will see that jurisdiction had been considered and decided in an earlier judgment. Now, the point is characterized slightly different later on in the skeleton argument. Sorry, in the skeleton. And if you've still got that open, Your Excellency, you'll see paragraph 54 of the skeleton.
So this is Reju's skeleton.
Reju, yeah. We're staying. This is all about Reju for the first part. So just in Reju's skeleton, paragraph 54, second line down, it said the injunction is ultra vires, sought to enforce foreign interim orders which are no longer in effect.
No,
and so
wait a minute.
forth.
Oh yes, I have it. Yes.
So it's that submission is not developed other than, as you can see, by reference to the test in LARMAG. So while the application and the skeleton appeared to hint at some sort of suggestion that there was a genuine jurisdiction problem, that doesn't seem to be what they're getting at. Obviously, we would say there is no jurisdiction problem, and Trafigura has made that abundantly clear. But either way, it doesn't appear that some separate jurisdiction point is advanced. So I'll go on and deal with what they do say under this heading, but I think the significant concern that we had in relation to the way this was being put was that they might come back, they might argue it once on a jurisdiction ground, and then come back and argue it again on a good arguable case ground. But I think last time they accepted that they couldn't do that. So it may not matter too much how these things are characterized. That's all I was going to say about what may or may not be a jurisdiction complaint. And then we move on to look at the serious issue to be tried. And there appear to be 8 points that were raised in writing, and we summarized them in our skeleton So this is my skeleton argument, paragraph 29, subparagraph 2, and there was no complaint. I think it was confirmed that was an accurate summary, but I'm working from memory, so that might be overgenerous to my recollection of what happened. But nobody suggested that this is an inaccurate collection of points, and we have referenced where it all comes from. So as you can see from the footnotes to paragraph 29, there's quite a few of them, we've gathered in these points from wherever they lay. They were a little bit scattered through the text of the application document. Now, some of them are not standalone points. They seek to address the alternative ways in which we put the case, but we say they don't actually deal with all of the ways. So the first two, and I will go through each of them, but the first two address direct enforcement of the US preliminary injunction. So the first one is the preliminary injunction had ceased to have effect. And I'll come on to it, but you'll recall that that point has now been dropped, as we understand it. And then the second point that's raised is that interim injunctions cannot be enforced in the DIFC. Now, the third point that's raised is that enforcement is not possible under the UNCITRAL model law. That, of course, was an alternative route for the enforcement of the US preliminary injunction and the US summary judgment order that we proposed. And then the fourth is that the US summary judgment order is not final, conclusive, and enforceable. And that's addressed to the declaration element of the US summary judgment. The money judgment supports the money claim and so is relevant to the freezing order, not the proprietary order, which is what we're dealing with here. So there were those two different elements of it. Fifth, it said Mr. Raveendran disputed jurisdiction in the US proceedings, and sixth, it was said that there was a breach of natural justice in those US proceedings. So 5 and 6 are defences to enforcement, if anything, albeit this, as we'll see, the natural justice point appeared to be raised actually in support of suggesting that there were good prospects on the appeal in Delaware. That was where it was said to be relevant. So we'll have to see in due course how that pans out. The seventh point, then, it said the court could not recognise and enforce the declaration. So that seems to be an overlap with the fourth point. You can't rely on the declaration to get us to proprietary relief, is the central argument there. And the eighth point is there's no independent justification for the proprietary order. So in a sense, 1 to 3 are targeted at enforcement of the preliminary injunction. 4 to 8 are directed at one of the alternative ways that we advance to support the proprietary injunction. That's reliance on the declaration in the US summary judgment order. And then within 5 and 6 are defences to enforcement at common law. And if one just pauses there and looks at the different arguments that we advanced, we say there is a gap. And I'll just remind Your Excellency of what we said at the ex parte very briefly and why I say there's a gap. If you're on, I can go to page 8710, please. And what I'm showing you is my ex parte skeleton.
Yes.
And then paragraph 126, you'll see we advanced 4 bases for proprietary injunction, for recognition and enforcement of the preliminary injunction, in support of the claim for recognition and enforcement of the declaration, under the model law, and then the fourth one, in support of the proprietary claims that continue to be asserted against Byju in the Byju US proceedings, which may in due course result in a judgment that is capable of recognition and enforcement. So one of the short answers to this whole part of Byju Raveendran's case is that they have not even begun to address this alternative basis on which we seek or sought the proprietary relief that was ordered. that there are ongoing claims which include relief which would require preservation and payment over of the alpha funds. I can show you that very quickly in the second amended complaint in the United States. It's at page 1491. And what I wanted to show you is just the prayer for relief in those proceedings. 1491, and you'll see when you get there, paragraph B of the relief.
Yes.
Just so you're aware, that your video feed is extremely choppy. I can hear you very well, but if at any time you cannot hear me, then do of course let me know, and
I'll let you know.
Thank you.
When you said mine's choppy, you can hear me, or is it?
I can hear you very well, but the video feed is choppy.
I see. All right. I don't think I can do anything about that.
No, I was just warning you in case it was reflected in the way that you were receiving me. All right. Page 1491 then. So just the prayer for relief under the heading there, you'll see paragraph B. There is claim for an award of A, the return of property to the debtor's estate that is subject to the avoidable fraudulent transfers alleged herein, and then damages. So there is a claim for return of property, and then over the page at 1492, there is at G a claim for an accounting of the alpha funds and an order to remit all funds owed to the debtor, including each and every transfer of alpha funds and those assets. And H is disgorgement of the alpha funds. And then I seeks orders in relation to constructive declaratory judgment that the second fraudulent transfer and any subsequent transfer or deposition of the alpha funds were ultra vires, void ab initio, and otherwise without force and effect. And two, the alpha funds are property of the estate. And then L seeks creation of a constructive trust over the alpha funds plus any applicable appreciation. So obviously, how different legal systems describe proprietary claims, it varies, but we would say these are quite clearly proprietary in nature and sufficient to support the injunction that Your Honour granted if this relief is made out. And so one of the ways in which we advance this claim is seeking an order in support of those ongoing bits of the proceedings under Article 15.4 of the new court law, which gives the common jurisdiction. And that approach is simply not addressed. So these technical points about whether or not interim injunctions can be enforced in the DIFC, for example, do not assist Mr. Ryju Raveendran at all. The questions of the status of the interim order don't affect this way that we put the claim. Now, at the last hearing, our recollection is that Mr. McNutt, on behalf of Ryju Raveendran, said he did not need to deal with that basis of the application. He did ultimately go on and try to deal with it. Essentially, his central point was there's no point in it, as far as we heard, because he said Mr. Raveendran does not live in Dubai and does not have control over the money. And we say that submission is quite unreal, but I'll come back to that, if I may, at the end of the argument. But what I was going to do was just run through, for now, these 8 different points that were raised and deal with them quite relatively swiftly. So reminding you, Your Honour, we're back in my skeleton 29 subparagraph 2, and just starting with A, the first point, in the first of 3 points about the preliminary injunction. The first argument was that the US preliminary injunction has dissolved. That was abandoned at the last hearing. There was an issue, if you'll recall, about the preliminary injunction, and it was suggested that because of the summary judgment, the preliminary injunction dissolved. And the issue was that because there were still outstanding claims which supported the preliminary injunction, that therefore the preliminary injunction had not dissolved until those claims are determined. And that's logical and coherent, we would say, because otherwise you get caught out if you get some small summary judgment on some small aspect of the claim, and the court would have to consider again whether to make a preliminary injunction. As we understand it, that was eventually conceded, so we don't have to trouble you any further with that. The second point is that it said interim injunctions cannot be enforced in the DIFC, and that I've given you the references. If you'd like me to show you, if ever you'd like me to show you where this is said, I can take you to it. But otherwise, I was just going to move up on that basis. Yeah. So you're aware. I can show you Article 31(4) of the new court law if you like. It's at page the claimant's authorities bundle, page 120. But I think you're as well aware of it. But it makes clear that interim injunctions can be enforced by this court, and there's never been any explanation of why the Raveendran says what he says about that. We say, and it's an interesting question actually, but we say nobody actually tried to enforce an interim injunction under the old law. And so there might have been quite an interesting debate to be had about which side of the fence the DIFC court was going to fall on this, because we don't accept the way it was put in the application was that the common law does not regard interim orders or injunctions as enforceable. And that was very much a statement which we say assumes that the common law is English law. And of course it's not, because we understand, for example, that Australian law permits the enforcement of foreign interim injunctions in certain circumstances. I think I was accused of pandering when I made that point, but it's a real schism actually in the common law as to where as to how they approach foreign orders of that sort. But I think what we'd say, and this is relevant for other points, so I'll make it if you can give me the time. It's well recognised that findings in foreign proceedings can be recognised in domestic proceedings, and then can be used, those findings can be used to support declarations and injunctions and other forms of relief that made in the enforcing court, even where the rule is that you don't strictly enforce interim injunctions. And so we recited a passage, an extract from Briggs, which essentially said it's not actually that helpful to say that there's no enforcement of injunctions, and describes that statement as effectively misleading. I don't know if you want me to show you that, but it's at Claimants Authorities, page 2173. I think we recite it in our skeleton arguments and in the event. Now, the way this was put in the skeleton arguments from Mr. Raveendran was to rely, paragraph 59, this is, rely on the case of Rubin and Eurofinance, to say the UK Supreme Court in Rubin and Eurofinance has held that foreign interim orders made in insolvency proceedings are not recognisable at common law. That case, Rubin and Eurofinance, was the one which says that you cannot enforce using the model law. And I will come back to that, but it does also endorse in English law the application of what's been called the Dicey rule, which is the test for jurisdiction of the foreign court on common law enforcement. Paragraph 60 of the skeleton argument then goes on to refer to DNB Bank, which of course is the case in which this court decided that in effect the Dicey rule was sufficient, if satisfied, to justify recognition and enforcement of a foreign decision. The case does not say anything about interim orders at all. So actually the position prior to the new law was that there was no decision directly on point. Nobody had ever turned their minds really to the question of whether foreign interim orders were enforceable. Now, paragraph 61 of my own friend Skeleton says the current case falls squarely within these prohibitions. So the suggestion appears to be that there are some sorts of prohibitions in the DNB bank case, but there aren't any such prohibitions. So it was just an open question. You don't have to decide it because you now have Article 31(4) of the DIFC court law, which expressly permits enforcement of foreign interim decisions. Back to the list of points to look at the third one. The third one is about the model law, and it said enforcement is not possible under the UNCITRAL law. And I don't know whether your Honor recalls this, but at the ex parte hearing, you rather left that to one side. So you said, I'm not going to look at that. Yes, we do say that it is at least reasonably arguable. It's something that could be decided at a later stage. Why do we say that? Because of the approach in both the United States and in Singapore. So this is a potential alternative route to enforcing the preliminary injunction. So we've got that injunction. Can we enforce that in the DIFC court? And if we get there, and if there's if the other ways don't succeed, we say you can through the model law. And just to remind you what we said, if we can go please to 8694. This is again back to my skeleton argument at the ex parte. And I'll just remind you what we said there, paragraph 73. We accept that in England, it's been decided that Article 21(1) of the model law does not permit this, does not permit recognition and enforcement of foreign judgment. However, we go on to look at what we would describe as powerful authority in Singapore, that the power in the model law to grant any appropriate relief in support of foreign bankruptcy includes the power to enforce a judgment. And that was the PT Garuda case in Singapore. And there were prior cases, but if you go over the page, you'll see reference to it at paragraph 75. And the point, it might be worth looking at this again. I don't know whether you're interested in this particular point, Your Honour, and whether it's something that we need to spend time.
Because I didn't really look at it previously.
Certainly. All right. It's in, I don't know if you have it, the Claimants Authorities bundle. There's been an updated version of it, but it's also quite lengthy. It's about 2,300 pages long, I believe. And if we go to page 1939 of that.
Wait a minute, I'm going to have to look for that bundle.
Of course.
I think it's going to take me too long to find it now, Mr. Montague-Smith. Perhaps if you tell me what it is,
let me
look
do
it up
that
later.
All right. So this was concerning the question of whether or not you can recognise and enforce a foreign judgment using the model law rather than going through common law enforcement. So if you have a foreign recognised bankruptcy process, can you just take all of the orders that are made in that process and import them subject to discretion and so forth using Article 21 of the model law? And the point there was that England had decided you cannot, and they said it's got to be governed by the common law approach or any other treaty that's in place. And the Singapore courts disagreed. Why did they disagree? Because under Article 21 of the model law, what it says is that the court may, at the request of the foreign representative, grant any appropriate relief, including, and then lists out various categories of appropriate relief. And I think what the process had been previously was to look at that list of categories and ask the question, is a foreign judgment one of these things? And the Singapore Court of Appeal, the Singapore Court, essentially said, well, why are we looking at the categories? Why aren't we looking at the chapeau, which says any appropriate relief? And so what they say at paragraph 145, and it's Claimants Authorities Bundle 1939, is that where relief in the form of the recognition and enforcement of foreign insolvency proceedings and orders is sought, we are of the view that the relevant provision is grant any appropriate relief found in the chapeau. And so what their view is that they depart from the UK Supreme Court on this, and they say model law enforcement can be used to enforce foreign judgments. Now, if that is right, then we point out that the DIFC version of the model law is precisely the same, materially the same for these purposes. That's at Claimants Bundle, page 99. So Article 21, 1 of the DIFC insolvency, the model law as it's attached to the DIFC insolvency law is in the same terms. So pausing there, the preliminary injunction exists in the US, and then really that's the end of that. You've got you could have a foreign representative in a foreign main proceeding asking you simply to grant appropriate relief, which is the recognition of that order. So again, all of these technical arguments just don't arise. And all we need to show is that that is reasonably arguable at this stage. You don't need to decide it, but it's another alternative way to getting to the relief that we seek. That's what I was going to say briefly about the model law. Then you have the 4th, 5th, and 6th points at paragraph 29 of my skeleton. And these are points about, in a sense, the merits of the claim. So firstly, Mr. Byju Raveendran says the US summary judgment order is not final, conclusive, and enforceable. He then says it's made without jurisdiction because Mr. Raveendran contested jurisdiction and it was contrary to natural justice. So these are things that are said in the documents about the US summary judgment order, not about the preliminary injunction. So they can only affect that way in which the claim is put. And we are dealing with the proprietary order, of course. And so for that purpose, the status of the financial elements of the US summary judgment order is irrelevant. So the financial elements being the orders for payment of damages. But as I say, one of the 4 ways that we argue for the proprietary injunction is in reliance on the declaration in the US summary judgment. So this is relevant. These merits complaints about the US summary judgment are relevant to that alternative way in which we put our case. I think we dealt last time with the jurisdiction argument. There were questions about whether it was final and so forth, yes. And I've dealt with that in a little bit of detail previously. It's now the points that were being made were that it was subject to an appeal and there was a motion to reconsider, and made the point that at least the common law, that's neither here nor there. So it's final and conclusive if it carries res judicata effect, and it does. So I wasn't going to repeat that. I also dealt in a bit of detail with the jurisdiction argument last time. And we say it's reasonably arguable, at least, that Mr. Raja Ravindran submitted to the jurisdiction of the US courts. In fact, we say that is an issue that is so firmly in our favour, it's capable of summary disposal, because it depends on what happened in the US courts. I'm not asking for that today, but we say that his submission is obvious from the documents, and it's quite difficult to see how the contrary argument can be raised. I just wanted to remind you, Your Honour, of that. If we go to page 1614, and we see the statement of defence and the prayer for relief submitted by Mr. Raja Ravindran. And he made no application disputing jurisdiction. There was no motion for dismissal on the grounds of jurisdiction in that case. You'll see that his prayer for relief, he sets out his various defences and puts in a full defence on the merits. And then at page 1616, at the bottom, after the 11th defence, he positively requested a judgment in his favour against the claimant from the US court. So again, I won't go back over all of the ground on that, but it's very difficult to see how, if you go to a foreign court and say, I want a judgment in my favour, you're not thereby waiving any or submitting. The natural justice point, I think, fell away somewhat as an argument. Why do I say that? Because in evidence at 8423.
Sorry, what page?
8423. This is Mr. Van Tol's witness statement.
Yes.
8423, paragraph 26. On the due process point regarding the US summary judgment order, he's responding to a complaint that I did not explain why due process is relevant to the enforcement issues in this court. And he says the relevance is that the violations of due process as a matter of US law show that the US summary judgment order is likely to be stayed or overturned by the district court. So it looks like that is being advanced not as natural justice complaint under DIFC law, that in other words, this judgment was obtained in circumstances which are so contrary to natural justice that the judgment cannot be enforced in this court. What is being said is, in fact, that as a matter of US law, it'll be overturned in due course, and therefore you can't assume that it will continue forevermore. And the bottom line in relation to that is that insofar as it's not explained, but it's likely to be a reference to the fact that because Mr. Raja Ravindran was found to be in contempt of court, he was not allowed to deal with certain issues in his defence. And the short answer to that is the mere fact that a party is not permitted to run a defence or any part of a defence procedurally does not immediately render the judgment contrary to natural justice. An appropriate use of court sanctions is perfectly acceptable, and this court would do much the same in appropriate circumstances. And so one would have to go on and look at those issues. So that we say really means that when one looks at these merits-based offences, they don't get off the ground. At least for your purposes today, you can accept that there's a real prospect of us succeeding in relation to those defences. Back to the list, the 7th point then, there is an attack on our use of the declaration as a basis for an injunction. So because we've got a declaration that the alpha funds belong to the claimant, they say, well, that cannot be used to create a basis for a proprietary injunction in this court. we say that is well arguable, even if we were dealing with strict common law principles. And this is where that passage from Briggs that I mentioned but didn't take you to could be of assistance. Again, just to remind you of the place, it's a Claimant's Bundle of Authorities, page 2173. And essentially, Briggs says you can take binding findings from another court and use to build on them, to build claims. And so if you applying that here, we would say, well, we've got a finding that the money belongs to the claimant, and one can use that to build a proprietary injunction saying, to the extent that you hold that money, you must not dissipate it. And that's all that really is required. And then the final point is simply an assertion, and there's what we have described as an extremely opaque section of the application, I'm afraid, which just appears to be saying that there's no independent justification for the proprietary injunction, independent of the US preliminary injunction, but it fails to engage with the point that there is an ongoing claim for proprietary relief in the US courts, and we are asking this court to hold the ring until that is decided. That claim, we say, plainly has merits, and there is a real prospect of it succeeding, just as everything else has succeeded to date. I mean, it was said at the last hearing that there was no evidence to support a claim against Mr. Raveendran, and the principal points that were made were that he said he did not have the money, and he said he does not live in Dubai. And it was said, well, the claimant is making this application, made it ex parte, knowing full well that those things were true. But how was the claimant said to know those things? Well, because Mr. Raveendran said them. And we would suggest, be forgiven for not taking his word for it at this stage in proceedings. Given the terms, in particular, of the US summary judgment order, we just say that the argument that there's no real prospect of establishing a proprietary claim against Mr. Raveendran is an unreal submission. We rely on the reasoning, amongst other things, in the US preliminary injunction. The whole point of enforcement is that we don't have to re-argue all of that. So we say we don't get here, but if we do, we say the reasoning is compelling. And I just remind you of this. It's been a little while since we looked at this, but we have looked at it. It's at page 1388. All right. And just to remind you, Your Honour, of the central reasoning of the US court, you will see that the US court reaches the conclusion at this stage that there is a reasonable probability of success on the fraudulent transfer claim. And then in the middle of the page, one of the factors, just picking out some of the important bits, the parties do not dispute that debtor transferred the disputed funds to camshaft immediately after incurring substantial debt. So that was one of the factors. If one puts oneself in the shoes of a responsible company director, do you incur an enormous amount of debt and then take some cash and send it off to camshaft? Then there is the passage which is now notorious and is in dispute, which is that Mr. Byju Raveendran is quoted as saying the money is someplace the lenders will never find it. And you'll recall that the lenders did write it down at the time, and there was a reproduction of the note. And if you want to look at it, it's at page 1454. In fact, Mr. Raveendran's position was that that statement was taken out of context. He doesn't say it didn't happen. He said it was taken out of context. That's at page 1055. But there's at least an arguable case that he said that, and if he said that, that is strong evidence in support of the claim. Byju claimed not to know why the payment was made, despite being a director of TNL, which authorised the transfer. And this was despite the fact that he authorised the payment. And that was in the cross-examination for the injunction. And there's a little bit of material there, if you want to look at it, where we can just pick out some pieces where he's made admissions, which we say strongly support the rest of the claim against him. So if we go to 1196, you'll see this is part of the cross-examination, part of the deposition. So you'll see in the middle of that page, he's confirming that Think and Learn made the decision to make the 380. This is about the 318 million cash transfer, and then line 22, as sole director and officer, you consented to the transfer. And then he says, for this I signed, if that's what you're looking into. Yes, I'm the person who signed. So he's the person who actually signed off on the transfer of 318 million. Why did he do that over the page at 1197? He did it because he was told to by TNL, and he didn't know why the direction was made at the time. Over the page at 1198, he says when he signed the transfer documents, he'd never heard of camshaft. And then on page 1200, he said he was sitting on TNL's board, but he just followed TNL's instructions to make the transfer. And then 1201, line 18, he confirms he was the only person who was looking after Byju Alpha's interests at the time. 1203, he confirms he signed the documents for the $215 million transfer. That's in July 2022 now. And he also confirms at 1205 that he signed the documents for the transfer of the camshaft LP interest to InspireLearn, and that he was sole manager of that company. 1207, he says he didn't know at the time why he made the transfer, and he still doesn't know. And then 1209, there's a relatively lengthy passage where he confirms that he doesn't know whether Byju's Alpha received anything in return from InspireLearn for the camshaft LP interest. So the upshot is that he was the one who actually effected the transfers. And there is, we say, more than enough evidence that there was absolutely no legitimate reason for those transfers. And it is simply unreal to suggest that he has no case to answer here. And you'll recall the judge said he was either being untruthful or he was the most incompetent officer or director in Delaware history. That's page 1392. I don't think the judge was indicating that he genuinely thought he was the most incompetent officer or director in Delaware history. So if we go back to the reasons for the court, that's back to 1388. You'll see at the bottom of the page, 1388, last two sent lines, the defendants have not presented a single piece of evidence to suggest that the camshaft transfers were made for any reason other than defrauding the debtors' creditors, and then says that the claim is reasonably likely to succeed. And Your Excellency, Your Honour can rely on the judgment for all of that. Much of it is not disputed. And to that, Your Honour can add the developments since this judgment. So the first thing, camshaft is found to have committed an actual fraudulent transfer. That's page 2490. page 29 of the judgment. And in relation to Mr. Raiju Raveendran, you will recall the second point that we just remind you of is that there was an episode in India where the Board of Cricket Control of India put TNL into liquidation. And in order to bring that to an end, Mr. Raiju Raveendran ultimately committed to and then did produce $17.9 million US. That was in July 2024. The evidence in relation to that you'll find at page 878. And it's paragraphs 100 to 105 which set this out. The point being that clearly Mr. Raiju Raveendran has access to substantial cash. And so you've got a position where he has signed for the transfer of a very large sum of money. There is no legitimate justification for that, or at least it's arguable. He has access to very large sums of money when he needs them, $17.9 million being an example. So the assertion that there is no prospect of showing that he retains control over some of the money, which falls within the proprietary order, is, we say, unreal in the circumstances. And indeed, when it comes to the 17.9 million, we've got the underlying documents. I don't think we really need to go through those, but they start at page 3180 if you'd like to look at them. And then we have, if Your Honour recalls, the Haler Declaration. We've got evidence from Mr. Haler about the luxurious life that Mr. Raiju Raveendran was leading. Some of that is on page 2314. And there's a bit of a difference, in fact, on this, in the sense that, according to Mr. Byju Raveendran, this lavish property that's described by Mr. Haler was rented by Mr. Raiju Raveendran. That's his evidence, is page 6227, paragraph 14b. Now, the reason I say there's a difference is because while Mr. Byju Raveendran says that was Raiju's property, rented property, Mr. Raiju Raveendran says he never lived in Dubai and he went on holiday there. And we say that in itself supports the application, because he's just lying to the court now. Or for the purposes of today, at least, there is a real prospect to be tried about whether he's lying about where he lived. We say we know that he was living in Dubai. It's not just his brother who says that. It's not just Mr. Haler who said that. He said it himself on multiple occasions. And I can give you a list of references if it's helpful, but there's a series of them. So 6967 is the deposition in the United States on the 15th of May. So that was shortly before the order was made. This was the deposition transcript that Mr. Raveendran stopped us showing this court because he designated the whole thing as confidential, which led to the difficulty immediately before the hearing, because there was the US protective order prevented us from showing it to you, but we needed to make sure that we had given Your Honour a fair presentation of what his case was likely to be. But if you get there and want to look at it at 6975, at the bottom of the page, sorry, I've got the page, 6975 at the bottom of the page, 6975 and over, he confirms that he's currently living in Dubai. That's line 21. 6990, he confirms again that he's living in Dubai at the bottom of the page, lines 24 and onwards and over the page. 6991, he says he lives there full time. Question, line 4, do you live there full time? Answer, line 5, yes. And then he says full time in a sense. I might be traveling for dad's treatment here in Abu Dhabi. So basically in Dubai, staying in Dubai and between Abu Dhabi. And of course, he now says he lives in India. On the bottom of the page, that one, he confirms that he lives with his brother and his family. So that would be the other defendants. And as we've said in these proceedings, his own brother says he rented a house in Dubai. He also swore 2 affidavits and gave a witness statement in these proceedings. And in all of them, he says that he resided in Dubai. That's at 5371, 5376. Sorry, 5371, 5376, and 6204. And he said the same in the United States at 1396, paragraph 4. And Mr. Haler said it, as I mentioned, at 2314. So in terms of the way it was put, was he doesn't have any of the money and he doesn't live in Dubai. And so the question for today is there a real issue to be tried about whether he's got any of the money or whether he lives in Dubai? And the answer is clearly there is. Ultimately, I mean, if one thinks about it, the idea that if you can show solid evidence that somebody has, well, it's admitted that he transferred this money, there's solid evidence that that was part of a fraud. The idea that we then have to go on and find out where that money is and demonstrate to you in concrete terms that it's in his hands is again unreal in these circumstances. These are precisely the sorts of circumstances where the courts say, well, look, you were clearly involved in that fraud. You know, to the extent that you still have access to that money, you must hold on to it and eventually deliver it up. But we've got all the fact that people don't normally participate in fraud out of their own goodwill. They normally get something out of it. And he's living this wonderful, lavish life, putting the pieces together. The inferential case, we would say, is very strong. He's using the money that he stole. That's all that I was going to say about good arguable case. We've got judgments from the United States in terms of whether we're likely to keep them, in terms of whether or not there's anything in his hands to catch. By the injunction, we say that there is a not just a good arguable case, but a very strong claim in relation to those. The next issue that is raised is the balance of convenience. And this only arises if you're not, we say this only arises if you're not simply enforcing the foreign order. So in other words, if the question is this a freestanding proprietary order, then the issue arises in the context of that test. It doesn't obviously arise if the question is, should we recognize and enforce the US preliminary injunction? And quite how you approach that is not set in stone by any authorities, but we would suggest that ultimately, given that it's really about enforcement, this court should ask itself the question whether that order was properly made, and not necessarily ask itself the question, would I have made that order if I was in the same position? But if you do ask yourself that question, we say there's the balance of convenience clearly favours making the order. Why? Because it's premised on it. Because if he has the money, then it's clearly fair and convenient for him to hold on to it. If he doesn't have the money, then he will be unaffected by the order. He raises 3 points. He says, firstly, the claimant's in bankruptcy. Secondly, the cross undertaking was not fortified. And thirdly, the preliminary injunction ceased to exist. The first 2 I will come on to in the context of the fortification application, if I may. The last one has been conceded. So actually, the points that are raised against me in relation to this particular issue all fall away. And we say, as I mentioned, if he's got any of the money, he's got to stop using it. If he doesn't have it, then the order will not bite. So on balance of convenience, it's very firmly in favour of it. And then when it comes to justice and convenience, the argument that was actually made was simply a repetition of the assertion that the preliminary injunction had ceased to exist, and that has been withdrawn. So really, that it all, once one gets to the point where one accepts that there's a good arguable case, it all rather collapses, we say, on the merits of the application, and that's not surprising, because when you get to the point that you can show that there's a real prospect of establishing that this person has our money, then ordinarily one would expect to be granting an injunction at that stage. What is left of this part of this particular application, set aside and continuation, is a litany of full and frank disclosure points. So with your permission, I was going to move on to look at those next.
Yes, please.
All right. Now, we say that the way in which those points have been presented, both orally and in writing, is, and I use this word advisedly, I think it is regrettable. There are a number of rules in this context. One of them is that parties are required to provide precise particulars of breaches which are alleged. And there is a reason for that, because the allegations are serious. And very often they're serious for the lawyers involved, because they are allegations that things were available to lawyers which were not explained to the court, or that legal principles were that the court was materially misled in relation to the law. Now, in the application, you've got 3 allegations. In the skeleton argument, it depends how you cut them up, but it's something between 12 and 15, we count them. I'll go through each and every one of them, but I just make this prefacing remark. Most of them are false, factually false. So the facts asserted in support of them are simply untrue. And that is, with respect, something which this court should be concerned about, because the issues on full and frank, many of them turn on what was said and done in this court, and that should be capable of accurate reporting by the lawyers involved. It is not about the litigation parties themselves. It's not about testing the evidence provided by a litigant, and we're always in a position where we take our client's side and we have to advance their case for them. But it is a different order of situation where you are making assertions about things that happened in this court, things that were put into documents, and it turns out, as I will show you is the case, that things are being said that are simply untrue by lawyers to this court. I would remind Your Excellency, Your Honour, of some of the principles that apply in this area, and we set them out. The quickest way for me to do this actually is probably just to show you where I say them in my skeleton argument. It's paragraph 66 of my Byju skeleton, if I can call it that, which deals with full and frank disclosure. And
yes, I have it.
Thank you very much. So we start by reminding Your Excellency of the MEX Group Worldwide case, which deprecates scattergun approach to full and frank disclosure applications, and reinforces the point that they have to be properly targeted because they are serious. And then you have a paragraph 68 reference to the distinct principles which are recited in the Globe Investment Holdings case of Justice Black, which itself refers to the principles set out in the Tugashev case. And I think I would summarize it like this. First, they need to be particularized and provided on adequate notice. So it is unacceptable to put them out simply in a skeleton argument, but there we have it, because the point being nobody has a chance to properly deal with them in the evidence. Second, it is not this is the point at subparagraph 1, you don't need to and you shouldn't raise every conceivable point. It should be properly targeted. The test, this is paragraph 68(2), the test is whether in all the circumstances the effect of the non-disclosure was to mislead the court. That's why it's so serious. It's principle 7, which we recite 3, it shouldn't descend into a mini trial about the merits, and scattergun approaches are to be deprecated. If there is a breach, there is discretion to continue. That involves assessing the importance of the non-disclosure, the importance of the duty, whether the breach was culpable, and the injustice that could result. And there are other ways to mark a breach, such as costs. And the principles should not be carried on to extreme lengths and used as a refuge of last resort. And the way we put it reminded Your Honour of the Darnitsa case, which is recited at paragraph 71 of our skeleton. Mr. Justice Burton, who I think is now sitting in the ADGM court, said that his timbers needed to be shivered, which is I think a helpful way to think about it. And in particular, it is just not enough to say that points could or should have been put differently or expanded upon. And then the final point we would remind you of is that this is at paragraph 69 above that, which is reference to the Public Institution for Social Security. And in that case, it was confirmed it is unacceptable to raise fresh allegations in a skeleton argument shortly before a hearing. And that's the reference in the bundle to that case is at Claimant's Authorities, page 1660, if it's helpful. So what are the questions? What are the points that are raised? And we start with the ones in the application. The first point, if we go please to page 478. Paragraph 103. That is the point that the US preliminary injunction has ceased to exist. The point is just wrong, and it was conceded at the last hearing. So what happened? The sequence was this: Mr. Van Tol, who didn't appear but gave evidence, accepted that the issue is whether the counts which underlay the preliminary injunction had been decided. And as against Mr. Raveendran, there's no dispute that they have not been decided. No one prior to the ex parte had previously suggested that the preliminary injunction had lapsed. So, for example, everyone is treating the contempt order as continuing. And that can only be on the basis that the injunction remains in place. So this is a speculative argument which ultimately has been withdrawn, and the claimant could never have anticipated that it would be raised. So there's no breach in relation to that. The second, and this is paragraph 104, is it said that Mr. Marsh, in his affidavit, gave the impression that the summary judgment order and the injunction were final and enforceable. This is, we say, also a hopeless complaint. But they are both final and enforceable, conclusive. The contrary is not even argued by Mr. Van Tol. And just to remind Your Honour, the order said on its terms that it was enforceable. That's at page 2590.
So what page was that?
2590.
Thank you.
The summary judgment order. And paragraph 7 of that said the terms and conditions of this judgment order shall be immediately effective and enforceable upon its entry. And you'll recall the reason for that was because the bankruptcy rules, in effect, would otherwise have suspended the time when it came into effect, and the judge was saying, no, it's enforceable from today. And so what was the point that was being raised by Mr. Van Tol? We see it at page 8420. And he says, well, the language that I've just shown you, this is the third line down on paragraph 13, the language that I've just shown you predated the reconsideration motion, and it does not answer the question of whether, as a practical matter, claimant could have enforced the US summary judgment order in another jurisdiction. He doesn't support that. So the suggestion is, well, maybe it was technically enforceable, but in practice, people would have waited to see. He provides no support for that. We don't accept it, but it's irrelevant in any event, because the legal test potentially was whether or not it was enforceable. That might have had a bearing on whether you were willing to act. But after that, it's just down to your discretion as to what you do, in the knowledge that there are attempts to dislodge the judgment. In relation to the preliminary injunction, of course, we never suggested to Your Honour that it was final and conclusive. It was always preliminary. So the second complaint is also hopeless. And then the third complaint is a cluster of complaints. If we go to page 479, please. It's really, one has to pick it out of this text, paragraphs 107 and onwards, but essentially it is a set of complaints about the use that it is alleged was made of the Raveendran deposition. And this is where the account, one of the areas where the account of what was done was simply untrue. So to figure this out, one has to then, I'm afraid, go back to Mr. Van Tol's witness statement to see what really was being said about this. And that is at back to page 8428. And it's paragraph 54. And what he says, and you'll recall this arose out of the restrictive regime for referring to the deposition. And paragraph 54, he says, third line down, counsel for claimant referred to the existence of the Raveendran deposition and then noted that claimant was confident that it had fairly portrayed Raveendran's assets in the UAE. Thus, claimant's counsel improperly implied that the Raveendran deposition supported the assertion of substantial assets in Dubai, when in fact the Raveendran deposition completely undercuts claimant's claim. That is not true. If you go to page 62, you'll see what I told you about this. I don't know whether you remember this, Your Honour, but
I do, yes.
I'm grateful. So it's 62 going down to 64, and what we did, we say, is make it abundantly clear that their position in that deposition was that they had no assets, or rather, I couldn't tell you what they said in the deposition, but I made it abundantly clear that we anticipated their position would be that they had no assets. And we say there's no possible way that you can read that transcript and see some implication being made that in the US they had, or Mr. Raveendran had said that they had assets, that he had assets in Dubai. And that's the center of the allegation. The allegation is that I came to you and I implied that he had told the US court he had assets in Dubai, and that allegation is, I'm afraid, quite false. So those are the three allegations that are made in the application, and then we have the skeleton argument and a raft of other applications. Raft of other complaints. And our threshold point is that you should simply refuse to permit them to be heard because they are not evidenced. No notice was given of them. They are sprayed out in an unsigned skeleton argument. There is no lawyer who is willing to put their name to this, although Mr. McNutt did say them, although he appeared to be unfamiliar with them because he thought they ran out at a particular point. I don't know if you recall that. And I pointed out he recited the ones that he relied on, and then I said, well, you've missed out a few. He said, well, let me finish. And I think Your Honour intervened to say, well, you said you had finished. But anyway, we say, someone who is registered on the website, in the court system, should be taking responsible for every skeleton argument that is filed. It's important because they are the ones who are exposed personally to wasted cost applications and other forms of complaints if the court takes the view that these sorts of points should not have been taken and crossed the line. And it's an important element of the discipline that this court has to impose, that when someone is going to make these sorts of complaints, that someone responsible has signed up to take responsibility. But I will go on and deal with them. They start at paragraph 75 of the skeleton.
Sorry, which paragraph?
75. It's on page 17 of the skeleton argument. Now, so starting with paragraph 75, I'll just give your Excellency a chance to read that. I mean, as drafted, that is impossible to understand. Now, what was said at the last hearing was that the thrust of this complaint was that we failed to tell the court that the claimant was an SPV. And that was the fact that we failed to deliver to Your Excellency. That is untrue. And we did, in fact, give a fair explanation of the claimant's role in the group. So if we go to page 836, start there. This is Mr. Marsh's affidavit, paragraph 12.
What page?
836. And it's paragraph 12, please. And it says in terms, the applicant is, second line, a special purpose financing vehicle for Think and Learn Private Limited. Now, it's hard to know what the relevance of all this is, but maybe it is being said that because it was taking in money for the whole of the group, that therefore supported the argument that the money had been properly used when it had been used to pay for things from TNL. But we did say in terms that it was an SPV for the whole of the group and a funding vehicle. And in the transcript orally, the point was again made. So page 70 this time. Page 70, second paragraph down, the claimant was incorporated in September 2021 as a special purpose vehicle, and it was incorporated to receive funding and then spread it through the group. So the allegation, this one, to the extent that it is a complaint to the extent that we can understand the complaint is false, just untrue. That's the first one. Paragraph 76 of the skeleton argument is the next one. We failed to disclose that the validity of the acceleration by Glas Trust Company is under challenge before the courts of New York. If the acceleration is set aside, it will result in invalidating all actions, including but not limited to the US summary judgment order, which these proceedings are premised on. This is also factually false. So we start with what you were told, page 840. Again, back to Mr. Marsh's affidavit, paragraph 22 this time, please. And 5 lines down, you'll see reference to the acceleration. These negotiations culminated as a result of additional defaults with Glas Trust Company, the agent for the lenders, accelerating the credit agreement and taking control of the applicant. And then we go down to page 868, please. He gives quite a long history. And paragraph 72. You'll see there, about 8 lines down, he refers to the appointment of Mr. Pole, and then he, about 8 lines down in the middle of that paragraph, he says, Byju and Tangible opposed the proceedings, arguing, amongst other things, that non-monetary events of default did not give rise to acceleration of the credit agreement. So the fact that the acceleration was challenged was disclosed in the evidence, but so that the assertion that it wasn't is factually false. But what is also factually false is that the acceleration is currently under challenge, or was when this skeleton was settled, or at least in a way that is materially relevant to these proceedings, because the argument is that because we're challenging acceleration, that will invalidate these proceedings, and that can only be because Mr. Pole's appointment was invalid, because there shouldn't have been an acceleration, and the challenge to both Mr. Pole and to Glas's approach have been dismissed, and we see that over the page at 869, paragraph 73. Final 2 lines of that. Following a trial in August 2023, the Delaware Court of Chancery again found in favour of Glas and Mr. Pole. And then paragraph 74 refers to a final appeal which was dismissed in 23 September 2024. So the claims themselves are not premised on acceleration. So the claimant's claim is simply the defendants have stolen the company's money. It was the appointment of Mr. Pole which is premised on acceleration. And that appointment is not subject to any further review. So there is no relevance to any dispute about the acceleration, but we did actually tell you that there was a dispute about the acceleration. So the complaint is false in a number of ways. The next complaint then is at paragraph 77 of the skeleton. I should say, Your Honour, I'm happy. I don't think we have a transcriber, so there's no third party to worry about in terms of timing. But if Your Honour wants to take a break at any point, then just let me know.
Well, let's see. We've been going an hour and 3/4. Yes, perhaps would this be a convenient time?
Yes,
or do you want
course.
to finish? Or do you want to finish the full and frank disclosure points?
Seeing as I've got about another 9 to go, I think that might take a little time. Yeah.
All right.
So I'm very happy.
All right. Well, let's take a 15-minute break. So we return at 5 minutes past the hour.
Very good. Thank you.
Yes, Mr. Montague-Smith.
Thank you. So I was up to, in the skeleton argument, Byju skeleton argument, Byju Raveendran, sorry, 77. So paragraph 77, what is said is that we failed to draw the court's attention to a detailed account of, in effect, what the money was said to have been used for. And that is that OCI said, it was said, had provided various things, tablets, marketing and so forth, and that was where the money went. It set off debts. And it's then subsequently said, and this is the final line of paragraph 77, that this detailed account was supported by invoices and bills of debts discharged by payments to OCI. This is again untrue in 2 ways. One is that we did give you a fair account, and the second is that there are not, in fact, any of those invoices and bills of debts and so forth. So I'll just show you that briefly. Firstly, at page 842, we see Mr. Marsh's affidavit. Paragraph 27 explains what the account was. About 6 lines down, in relation to the alpha funds themselves, even though the terms of the first and second promissory notes required that the 533 million be repaid to Camshaft in 3 years' time, according to OCI, Camshaft and Byju, the alpha funds were in fact purportedly offset by OCI in order to partially settle as far as the applicant is aware at this time, undocumented debt owed by TNL and its subsidiaries, but again, not the applicant, to OCI for allegedly the purchase of electronic tablets, certain promotions and advertising, and OCI's fees for the same. So that was the evidence. What did I tell you, Your Honour? It's page 75 of the bundle. It's in the middle of the page. I tell you that effectively that is what's being said, that it's to discharge debts. Debts appear to be undocumented. The relevant part of the declaration is at page 1944. So this is what it said was not shown to you. And I don't think you were taken precisely to the declaration itself, but the relevant part is not a detailed account, as suggested. 1944, paragraph 39. And it just makes the assertion in broadly the same terms that we provided it to Your Honour. In order to secure various purchases made by OCI towards media advertisements and other allied business purposes, OCI had a right to set off against the alpha funds. OCI set off its outstanding dues against the alpha funds. And so there wasn't a detailed account. It's also false to say that there were supporting invoices. If you go over the page to page 1945, you'll see the exhibits to this declaration. And none of them is directed at this particular, establishing the particular debt. And if you had the time and the inclination, you could go through the ensuing documents, and you would not find any invoices for tablets or marketing or anything like that. So again, you've got an allegation that is factually false in multiple ways to make a full and frank disclosure application. That's paragraph 77. The next one is paragraph 78 of the skeleton. And what is said there is that we gave Your Honour an inaccurate picture of TNL's management, operations, corporate governance structure and decision-making process. Now, that's an extremely vague allegation. It's not said how the picture given to you was inaccurate. And we would say it's completely irrelevant, certainly in circumstances where Mr. Raveendran ordered the transfer. He was the only officer looking after the interests of Byju's Alpha. I showed you that. And he made the transfer. He signed the documents for the money to go out in circumstances where he had no idea why he was doing it, he said. And either that was true or it was false, and he did know. And he knew that it was to steal the money. Obviously, we say the latter, but there we have it. It's got nothing to do with TNL's management, operations, corporate governance. Paragraph 79, the allegation is that we failed to disclose, quotes, the multiple complex network of parallel proceedings which Glaz is pursuing inter alia against Raveendran. And then says, nor have we addressed how each of these proceedings are legally and factually inconsistent with one another, as also material non-disclosure. And also in relation to the challenge against Glaz's authority. Again, it's quite difficult to pick out from this what precisely is said to have happened that we ought to have brought to your honour's attention. It is not true that we failed to tell you about parallel proceedings which Glaz was pursuing against Mr. Raveendran. That's 868 in Mr. Marsh's affidavit. You have there a full account of all the relevant proceedings. You'll see it under the heading E. And so in terms of the proceedings actually brought by Glaz, that is the funding, that's the body representing the banks. Paragraph 71 and 72 and onwards set out an account of the proceedings which were commenced to have Mr. Poll confirmed as a director of the claimant. And so there's a full account of that, and obviously there was quite a disputed process there. At 881, page 881, Mr. Marsh explains the circumstances of an insolvency petition filed by Glaz against TNL. That's paragraph 110. And there are various other insolvency proceedings, but just focusing on proceedings brought by Glaz, paragraph 115, there is there a reference to an application brought by Glaz for an injunction. I'm told that there are no proceedings by Glaz against Mr. Byju Raveendran, certainly in India. He has challenged various processes himself, but it is extremely unclear, and there is no evidence to support the allegation that there is some other claim brought by Glaz against Mr. Byju Raveendran or anyone else, which is material to these proceedings and which was not disclosed. There's just this sort of very vague allegation. The reference, there's no footnote to this paragraph. There's no explanation of what was not disclosed, and so it's very hard to give you much more than that. There's reference obviously to, at the end of paragraph 79, the challenge to Glaz's authority. That's not a claim brought by Glaz. That's a challenge brought by someone else, and that might be a reference to the US 225 proceedings, which we saw I mentioned it. It's back up at page 868 and paragraph 71 and so forth. And we've been through that and how it was dismissed. But all of that was out there. It's not obvious where any of this goes. So I'm afraid that's the best I can do. We say we've given you a complete picture of all the proceedings that were out there, and there's no evidence to dispute that. Paragraph 80 of the skeleton is an allegation that we failed to disclose allegations of wrongdoing on the part of Glaz, which were made not only by Mr. Byju Raveendran, but also the court-appointed resolution professional for TNL in the insolvency proceedings in India, and also a failure to disclose that the Ministry of Corporate Affairs in India indicated considering referring to the matter to the Serious Fraud Investigations Office. As far as we're aware, that is also factually false. If we go, please, to page 880, Mr. Marsh's affidavit again. Paragraph 108. In the interest of transparency, I understand from press articles that Byju is reported to have filed evidence alleging that Glaz has exercised some sort of improper influence over Mr. Srivastava, the interim resolution professional appointed for TNL CIRP. Glaz has rejected the allegations. That's all that we are aware of. The skeleton suggests that the Ministry of Corporate Affairs in India is considering referring the matter to the regulator. There's no evidence of that. We're not aware of it, so we don't know who the regulator has indicated that to, if they have indeed done so. But ultimately, this appears to be an allegation of, well, wrongful conduct. It's described as wrongdoing. We don't know what. But the reference to the Serious Fraud Office appears to be intended to imply that there's an allegation of fraud made against my client for which there is no evidence whatsoever. And so again, we say these are not this is not the way to put forward serious allegations to this court. Then we have paragraphs 82 to 84 of the skeleton argument, and that is about whether or not the US preliminary injunction ceased to be effective. Those were expressly dropped in oral submissions. The reference is page 9511 of the bundle, lines 3 to 12.
I'm sorry,
so
what page?
9511.
Yes.
Lines, and that's the transcript of the last hearing, and that is lines 3 to 12.
Thank you.
Where Mr. McNutt withdrew those complaints. Then we have the skeleton argument at paragraphs 85 to 86. And there's paragraph 85 refers to the motion to amend the US summary judgment order and the pending notice of appeal. And paragraph 86 says these were not disclosed to the court. That is also factually false. Again, I'll just have to show you the evidence. Page 861. Paragraph 59, this is back in Mr. Marsh's affidavit. Mr. Marsh, paragraph 59 refers to the notice of appeal. Paragraph 61 refers to the reconsideration motion. And then page 81 is back in the transcript of the hearing. Page 81, second paragraph down, I should also say, Byju has appealed against this, and he has also sought reconsideration of this judgment. So again, you've just got, in an unsigned skeleton argument, a false allegation of quite serious wrongdoing. Paragraph 88 is the next one of the skeleton argument. Second sentence. BA failed to inform this court that RR had raised a jurisdictional objection in the US proceedings and that there was no finding of contempt, obstruction, or non-cooperation made against him. Again, that is false. We did explain the way in which he had mentioned jurisdiction. So it wasn't even that he had positively mentioned jurisdiction. And just to summarize, and I'll show you this, but ultimately what it was that in the second amended complaint, jurisdiction was asserted in certain paragraphs. And those paragraphs, in relation to those paragraphs, Mr. Raveendran had said, in some cases, those are conclusory, so I don't need to respond, but if I do, I deny. So I think that what we did was we brought that expressly to the attention of Your Honour to say, well, it might be said that that is some sort of reservation. These points were raised in the skeleton and orally. So skeleton is at 8685. And paragraph 51 of the ex parte skeleton. We say, although Byju's answer to the second amended complaint contained bare denials of the passages which asserted the jurisdiction of the US court, he did not affirmatively raise the defence of lack of personal jurisdiction, nor did he move to dispute jurisdiction by filing a formal motion to dismiss. Now that's factually accurate. And the point is that we were bringing to Your Honour's attention the threads that might be used to piece together some sort of argument that there had been no submission. So we're not obliged to say he didn't submit because we don't take that position. We say he didn't submit. He might argue otherwise, and here is the basis on which he might say that. So again, the way it is put is quite misleading. And then orally, I made that point to Your Honour at page 101. We say, so if you start at page 100 at the bottom, we say he submitted a defence on the merits. And then over the page at 101, I say, to be fair, his defence on the merits included bare denials of the paragraphs in which jurisdiction was asserted. They are not, he never took a jurisdiction motion out, and not only that, but in his prayer for relief in those proceedings, he actually sought a substantive decision on the merits, we say. And then you say the standard is legally reasonably arguable, and we confirm that. So we say it is just wrong to say that we did not raise in a fair way the availability of arguments about jurisdiction of the US court and submission to the US court. As to the complaint that we told you that he, or gave the impression that he'd been evasive, but there had been no finding of contempt against him, that also is simply false on the facts. If we go to page 1812, there's an order from May of last year, paragraph 1, Byju Raveendran is found to be in civil contempt of court. And then again, page 1888, 1 3/8. So the decision from the 5th of August, supplemental order on finding of contempt, paragraph 1, as set forth in a contempt order, Raveendran is in contempt of court for failing to comply. So again, false on the way it was presented, false on the facts. Skeleton paragraph 90 is the next one. And it said, BA failed to disclose RR's deposition, dated 15 May 2025, was protected under a binding protective order issued by the bankruptcy court. And then paragraph 91, they say, we did not disclose that we had sought to vary it and had failed. Again, these assertions are factually false. Page 915 is the evidence. So this is a second affidavit signed dated 20th of May, so just before, quite shortly before the hearing, because the issue arose shortly before the hearing. Page 915 sets it out and explains all about the depositions, the protection order, and then over the page, paragraph 9, the attempt to vary that order. The fact that, I think I mentioned this expressly to Your Honour as well, the fact that the US court had effectively said, well, it's up to the DIFC what they want to do about it. But it did leave us in a bit of a quandary, because there was closed material which we couldn't tell you about, but which could have been relevant to the merits. But we found another way to give you a fair picture. In the skeleton, paragraph 92, they complained that the facts only surfaced in the second affidavit dated 19th of May, a day before the hearing, and then in the first affidavit of Mr. Horinsky dated 30th of May, after the injunction was already granted. The facts in relation to that were known were set out in Marsh 2, and that was all brought to your attention, not just by filing Marsh 2 and asking Your Honour to read it, but by bringing it all to your attention orally. And that is at page 62. And I think I've shown you these passages where I explained what the problem was. And then at 64, I asked Your Honour to read the affidavit in the middle of the page, which I understand you did. So I think that is all of the full and frank disclosure points that are raised against me. We, of course, say that there is nothing in them, and more than that, these are not acceptable allegations. What is left? What is left is firstly fortification, then security for costs, and then this minor point on alternative service. So what is said about fortification is that if you're going to continue the order, Your Honour ought to require us to fortify the cross undertaking. It was at various stages suggested that no cross undertaking was given, and in fact the US court was told that there was no cross undertaking, and of course that is false. Now it may be that the US lawyers misunderstood what a cross undertaking was, but it was repeated in this court by DIFC lawyers that there was no cross undertaking, and that was simply false. The way it's come out though is to say, well, there needs to be fortification. And the short point on fortification, I won't labour this, the short point on fortification is that there is no evidence of loss, or on the basis of which this court could anticipate there could be a loss, and that is a requirement. And I just want to show you, if I may, 3 short passages from cases on this. But I can't, because you haven't got access to the bundle. So let me give you the reference, yes, and I'll read it. I'll read it into the transcript, and then hopefully, if in due course you can get that. Yeah. The first is an Energy Ventures case, Energy Ventures Malibu Oil, which is a decision of the Court of Appeal in England, and Lord Justice Tomlinson gave the leading judgment. If we go to, if you get there, it's Claimants Authorities Bundle, page 1354, and paragraph 53 at D summarizes the principles. And I'll just read that out so you've got it. The principles could equally be summarized, as Mr. Justice Hamblin did at paragraph 31 of his judgment, as a requirement that the applicant for fortification show a good arguable case for it. In this interlocutory context, showing a sufficient level of risk of loss to require fortification is synonymous with showing a good arguable case to that effect. In some cases, the assessment of loss may be at the interlocutory stage difficult. It is in such cases that an intelligent estimate is required. An intelligent estimate will be informed and realistic, although it may not be entirely scientific. So the position is that there needs to be some evidence to support a real risk of harm flowing from the injunction. The court will not be too strict about it, and so will take an intelligent estimate. So it's not a question, you don't want to have some sort of contested trial with competing experts, but there must be something. The second case is a case called Spence, and it's at bundle, Claimants Authorities Bundle 1822. That is, the relevant passages are at paragraphs 19 to 20, really. And it refers back to a decision of Mr. Justice Popplewell, as he was in the Phoenix Group case, and he says he's setting out the requirements, and it says, number 1, first, that the court can make an intelligent estimate which is informed and realistic, although not necessarily entirely scientific, of the likely amount of any loss which might be suffered by the applicant by reason of the freezing order. That's the context it was in. Secondly, that the applicant has shown a sufficient level of risk of loss to require fortification, that is to say, has shown a good arguable case to that effect. And thirdly, that the making of the interim order is or was a cause without which the relevant loss would not be or would not have been suffered. And then the appellants emphasised that an application for fortification could not be based on mere assertion or supposition, but required an evidential foundation, referring to numerous authorities. And then the judge says, however, that is not, in my judgment, a separate requirement, but merely an obvious aspect of the need for the applicant to demonstrate a good arguable case, it being impossible to demonstrate such a case without an evidential foundation. And so the bottom line in this case is, if one thinks about what harm could this respondent suffer as a result of this order is just, when I say this order, we're not talking about the freezing order, we're talking about the proprietary order. And so this order is simply an order saying, to the extent that you've got the alpha funds in your hands, don't use them. And his assertion is, I don't have the alpha funds in my hands. So his own case is that he can't suffer any loss. And not only that, there's no positive evidence that he could. And there's a similar answer to the security for costs application. There are a number of answers to the security for costs application, but one of them is simply there has been no provision of any statement of costs that has been incurred and no estimate of costs that will be incurred. That is a requirement of the rules. Rule 25.99 states that an application must be supported, by various things. And at 3 and 4, it requires those things, a costs order from the past and a cost estimate for the future. Your Honour may recall from last time there was a bit of surprise on my side that there had been, in the face of the freezing order, no notification in accordance with that order that money was being used to pay costs. So it had the usual notification order. They can use money to pay costs, but they have to give notice of where it's going to come from. And there had been no letter of that sort subsequent to the parting of ways, if I can put it like that, of the representation of the defendants. And what was said was that nothing had been paid to the DIFC lawyers at that time. That's in the transcript, page 9614, lines 15 to 16, and lines 28 to 29. And that raises the question of what the arrangements really are between Mr. Byju Raveendran for payment of costs. And we have no idea whatsoever, but what we do know is that it must be something of an unusual arrangement. But in any event, the starting point is you can't possibly grant an order for security for costs if you aren't even given any inkling of what those costs are and what they will be. We do say this is not an appropriate case for granting such an order in any event, and we raise a few points in relation to that. The first point is that there's a judgment against Mr. Byju Raveendran for $540 million. The second point is that there is no evidence to support the suggestion, the assertion, that the claimant would be unable to meet the costs. The claimant is in Chapter 11 proceedings in the US, but it is pursuing litigation in a variety of different places. And whether or not it would be able to meet a costs order would depend very much on what that costs order is likely to be. And so it's not just a question of saying, well, I'll make a security order in principle, and then we can figure out what the numbers are subsequently. You can't even get to that point where they can say the claimant will be unable to meet costs orders. The claimant is able to spend money on these proceedings and has done so. And you've got, in fact, a costs statement from my side, which indicates that substantial money is being spent on my side by the claimant. So that's the second point. The third point is it is exceptional, we say, to order security against a trustee in bankruptcy. And we refer to a case called Kariva, which you find at Bundle Claimants Authorities, page 1808. And paragraph 5 of that, it's fair to say, records the submission that it would be exceptional to make an order against a trustee in bankruptcy, referring to some older 19th century case law in relation to that. I think, having reread that decision, I wouldn't necessarily present that as some sort of authority that is correct, but it didn't dispute that principle, and indeed a security order was made in that case, even though there was a trustee in bankruptcy. But we do say that there is a principle of reluctance, if I can put it like that, to order trustees in bankruptcy to offer security. The fourth position, for the fourth point, we say that there is no arguable defence to this claim. Now, we understand that in a security application, ordinarily the court's not going to look too closely at the merits of the case, but in this case, you have seen the shape of all of the defences that will be deployed, because they've been deployed either in this application or in the jurisdiction complaint. And so the court is in a position to take a view, at least in a broad way, of those defences, and we say they have no substance. So when one thinks them through, what is Mr. Byju Raveendran going to say? He's going to say, I never submitted to the courts in the US, and he hasn't explained why the points that Your Honour made or accepted as being at least arguable are wrong. So, for example, Your Honour took the view that it was at least reasonably arguable that in enforcing foreign orders, this court will now look at the test that it would apply if it was in the equivalent position. So there's no comment on that whatsoever. There's no answer to the point that he positively asked the US court to defend, to issue a judgment in his favour, dismissing the claim of finding various things, and that amounts to submission. And on natural justice, his response is, well, I wasn't in breach, I wasn't in contempt. But he was, and we'll see a bit more about that when we get to Byju. But in any event, we say there is authority to this extent that a claimant who is highly likely to succeed at trial should not be ordered to post security, and that is in the bundle at Claimant's Authorities, page 1089. Now we accept that you would have to take a fairly strong view of the position in the proceedings. But the paragraph 24 of this case says, a claimant resident abroad whose case at the moment of the interlocutory decision appears highly likely to succeed at trial will not be required to lodge security for the defendant's costs. And we do say that we are in that field. And then the final point that I would make is this. Mr. Byju Raveendran is liable for costs orders already from this court. And so if you were minded to say, well, there's going to be, and if you dismiss the discharge application, continue the application, there's going to be a costs order in his in our favour against him as well. And if you were otherwise against us on security of the costs, one option that you would have would be to suspend the enforcement or require him to pay that money into court instead, so that it could sit there and wait for the outcome of the proceedings. And unless you know what he says he's going to spend, you can't possibly reach the conclusion that at least would be inadequate. So it would be inadequate to protect him. So in other words, in circumstances where he's just in serial default of costs orders, it would be, we say, inappropriate to require the claimant to put down more money to get to judgment in these proceedings. But one way or another, we say you ought to dismiss the security of costs application. Now, I made too much out of this, but there is, we think, an alternative service complaint. We don't really see the purpose of it. It was at one stage said that it went to a question of jurisdiction. And I think in your judgment, Your Honour found that it did not. It was about bringing the proceedings to the attention of the party. Now, I don't think there's any dispute that Mr. Byju Raveendran was served in accordance with the terms of the alternative service order. The issue was whether or not it was appropriate to make that order in the first place. There were a number of reasons for it. The first is that this is a freezing order case, and multiple defendants needed to be served all at the same time. And these sorts of orders are routinely made in freezing order cases. And if you had the authorities bundle, you would be able to turn to page 1620 of it, where you would see a passage from the Neward Partners and Astor Maritime case, Mr. Justice Foxton as he was, where at paragraph 51, he makes this very point. It says, just to read it out so you know what I'm talking about, even leaving aside the issue of whether the bilateral service treaty between England and the UAE requires a different test to be adopted to that which is applied in Hague Convention cases so far as alternative service is concerned, I'm satisfied that there is a special need for urgency when a without notice freezing order has been made, which meets the test of special circumstances where service under the applicable convention might delay the point at which the order is formally served on the respondent. So that the fact that you have an urgent freezing order in the first place will often justify, maybe not universally, but will almost always justify an alternative service order if that proves to be a quicker way to go about things. The second point is that it was necessary to serve all of the defendants at the same time. And obviously, personal service is going to be more difficult. It's going to be more difficult to achieve that with personal service than by sending emails. And then the third point is that attempts had previously been made to serve Mr. Byju Raveendran and Ms. Golkanath personally with the US proceedings. And you may recall the evidence to the effect that security guards went down to the premises and were sent away, and they had to be served in a different way. It was said that that is not a good reason in relation to Mr. Byju Raveendran because it is evidence about the other defendants, but we say that it is obviously relevant because they all live at the same address. Now, Mr. Byju Raveendran now said he lives and lived in India, but we say that for the reasons I won't repeat, that is obviously false. The point was that he was saying in the US proceedings, and his own brother was saying in these proceedings, and ultimately he said in these proceedings that he lived in Dubai, and the address was one which we had previously been unable to access. So there were ultimately three very good reasons for alternative service, as I say. As a freezing order, it was necessary to serve three people at the same time, and they all lived at an address where we had previously been unable to serve. And frankly, we say the fact that he's taking service points and changing his story about where he lives rather reinforces the need for the order. So that's
where does it go if he was right that the alternative service order was not rightly made? I don't know where that goes, given that he has subsequently responded to it.
Well, quite. I mean, we say it doesn't go anywhere. I suppose he might say that the effect of it is that the excuse me, the claim form has never been served, and therefore the time for service has expired. He might say that, I suppose, but there we are.
Okay.
I mean, I've had it in another case where the argument was made, and essentially the argument was being made that the result was that the claim form had expired, and therefore you were in the specific rules in the RDC which deal with retrospective applications for extension of time to serve a claim form, and those are stricter than the prospective applications, and therefore I think in that case it was being suggested that essentially the claim form was a nullity because it had expired before service. If it matters, in that case, Justice Jeremy Cook took a fairly robust approach to his case management powers and said, I'm not that interested in these sorts of arguments because it's different in England where these sorts of rules were crafted because jurisdiction depends on service. And so service is jurisdictionally loaded, if I can put it like that. Yeah. Whereas here we're just talking about making sure people know and have the right documents. And if you're in court arguing about it, then the chances are you know about it and you've had the documents. So it's a rather arid debate, we say. In terms of the order then, the draft order is at page 328. I should say that's it in terms of the arguments on the actual applications by and against Mr. Byju Raveendran, but 328 is the draft order for the continuation as against Mr. Byju Raveendran. And nobody has really looked at that and made any particular observations about the form of the order. It's obviously, rather than saying it continued, the previous order continues until further order, it reproduces the whole of the order. We can do it either way, but that's the way we've done it. And we do seek our costs at the end of it, you will see, and we seek them on an indemnity basis. And I can develop that in due course if you'd like me to. But at this stage, we think that is a reasonable request, if I can put it like that.
Well, I think you better tell me why.
Certainly. Excuse me, so 1 second. Sorry, I think I might have said that cost orders have already been made against Raiju Ravindran in the DIFC proceedings. Actually, I think that's not right, I'm being told. And in fact, what's happened is that costs were reserved on the collateral use and further disclosure and for jurisdiction as well. I mean, I think what we say is on the principle of all of these things. We've succeeded on jurisdiction, we've succeeded on collateral use and further disclosure. So in principle, costs ought to follow the event in relation to those. In relation to the freezing order and the continuation and set aside, if you are with me on my submissions, then we will have succeeded on those applications as well. And I think we would say that the ordinary approach is where you have a contested continuation, that costs should follow the event of that contest, because money is spent specifically on identifying whether or not the current test at the interlocutory stage is satisfied for the grant and continuation of these sorts of order. So it should, sometimes it's argued that the cost should be reserved off until the end of the case, but these are a discrete phase of the proceedings. And if you're with me, your Honour will accept that the right answer is that the orders remain at least until trial. And that's all that we have been seeking, and that's all that we are arguing about. So the costs of having that argument are discrete and don't turn on the outcome of the final proceedings. So that's why we say we should have our costs of these elements. Why do we say that they should be on the indemnity basis? I think we say it for two reasons. One is the nature of the proceedings, and the other is the way in which they have been advanced. Now, in relation to the nature of the proceedings themselves, this is also obviously a very substantial fraud claim. One international court has already found Mr. Raiju Ravindran has participated in effectively the theft of a very large sum of money. Now, the question of whether you are going to recognise and enforce that judgment has not been determined, but what you can see from it is that you've got Mr. Ravindran, who admits that he transferred this money away. He admits he's got no good reason to profit for it. And so the idea that in those circumstances he should not be bound by orders which require him to keep in his hands any of the money that he still has is, we say, pretty preposterous. And so that is part of the reason why we say we would like our costs on the indemnity basis. The other part of why we say it is because of the way in which this case has been run. It has been quite extraordinary in our submission. It's taken a huge amount of work, and I referred you to paragraph 29 of our skeleton argument for this, where we had to do the work of the respondent himself to pick out from a long and dense document all of the points and recruit them to something sensible. And then after doing that, we were met with about 15 new allegations of full and frank disclosure. The way in which that last hearing went as well, if your Honour recalls, we had anticipated 2 days would be sufficient. And I think I spoke for about 2.5 hours in that 2-day period. And Mr. McNutt, on behalf of Raiju Ravindran, spoke. And also we dealt with the collateral use application too, to some extent, but he spoke for the rest of the time. And his submissions ranged extremely widely and were not focused. And they were the result, they were the cause of the adjournment. And at one stage, he was proposing that we should have multiple hearings of multiple days. In the end, we managed to find 3 days of my time, their time, and your Honour's time, which is not precious. And look what happens. The day before the hearing, the business day before the hearing on Friday, we get a letter. And what does the letter say? It's incoherent. It says, well, you prejudged things. and therefore and makes it completely unclear whether they're going to resist or not. And then we're told, well, they haven't got counsel for the hearing, albeit counsel is online, and Mr. McNutt was for a period online. So there's certainly no good explanation for why we have ended up having what is in effect a wasted adjournment, which has required the incurring of substantial additional cost to get up a 3-day hearing, which looks like it's going to be over in a day. But everybody's diaries are committed. And then there is the content of the allegations that were made. I've been through everything that has been said against me in relation to this, and there's two parts to it. One part is the case that is put is not coherent. So there are gaps in areas that haven't been addressed, and there are assertions of law which aren't right. You know, this court cannot enforce an interim injunction. Well, just read the court law. Now we have to spend time on this stuff. And then there is the way in which the full and frank disclosure points were made. And I have to say that is quite unacceptable. I won't go back over it. I do understand that this court is not the English Commercial Court. I do understand that there is to be a degree of latitude to litigators, which perhaps you wouldn't get in certain other forums. I do say it is important that the DIFC does not end up becoming just another arbitration light forum where people get away with murder and there's just no discipline, because the result of that is very, very long delays, huge costs, and it makes the job of the court that much more difficult. So at this stage, what we ask is that the court mark its disapproval of that conduct with an indemnity costs order. I think some points are made on costs in the letter that was sent by Hamdan al-Shamsi law firm. It probably, if you're considering costs, you may want to give them another opportunity, I don't know, to deal with that, but they could be here and they should be here, we say today, to deal with whatever comes up that's incidental to the application. And they do actually make some submissions on costs. It's right at the end of the bundle. I think it's the second to the last page. And essentially, I think that what they say is that they're taking the step to avoid further costs being incurred by the parties. But by the 21st of November, which is the date of the letter, that's Friday night, this came in, all the costs have been incurred. So they should have made that decision earlier. And frankly, they shouldn't have. They should have told us we don't oppose continuation. And then we at least could have saved the costs of the hearing. The other points that they make, and I believe this is at paragraph 14 of that letter, this is page 11318, they say they oppose any assertion that additional costs have been incurred, given the matter has already been prejudged. There is no material change or development, and the claimant has relied upon the same skeleton argument. Just dealing with those in turn. I mean, the allegation that the application has been prejudged is in itself pretty serious. I mean, it's essentially an allegation of judicial bias, and it just shows you that there is really no restraint here. No material change or development. That's probably true, but we do still have to come back and meet the litany of points. And the fact that we have the same skeleton argument, I mean, obviously we don't just charge, I'm afraid, for skeleton arguments. The idea that no additional costs could have been incurred is obviously just nonsense. So, and then of course there's all the costs of the original hearing. We have a cost schedule. I know we don't have a cost schedule for Byju, I'm afraid. So all I can ask from you at this stage is an in-principle order for costs. And we do say this is the kind of case where indemnity costs is justified. Your Honour, that is all that I was going to say about the position of Mr. Byju Raveendran. It's taking me a little bit longer than I had hoped, but
All right. Well,
yeah.
Well, we're coming up to 1 o'clock. If I've got my times right.
Yes, we are.
We are. And I think we should take a break, at least for the court staff.
Yes.
Perhaps, trying to remember, for you it's mid-morning, I think, Mr. Montague-Smith. Perhaps if we were to make it 45 minutes, would that be suitable?
Of course.
All right. Well, we'll resume at 1:45 GST, Gulf Standard Time.
Thank you.
Thank you. Yes, Mr. Montague-Smith, are you ready?
I am, thank you. Just one point that's been drawn to my attention over the lunch adjournment was that having asked you to make the order in the terms that I showed you, I've been reminded that Your Honour has already continued both injunctions until further order of the court. So just to show you the Byju order, that is at page 41 of the bundle. And this arose in the context of the applications to adjourn the return date. And at page 42 of the bundle, you will see on paragraph 1, you've already ordered that the injunction shall continue until further order. And that was obviously subject to the continuation and discharge applications. So it may simply be that if you're with me on continuation and discharge, that you can just simply leave it as saying the continuation application is accepted and the discharge application is refused, and then deal with costs, rather than having to repeat the order in the form that I showed you at page, I think, 328 of the bundle. So in terms of what we do next in relation to those items, we can do it in a number of different ways. If Your Honour is content that you have what you need, you can just decide what order to make, or if you'd like me to draft something, then I'm very happy to do that equally. As I say, I think it would be very straightforward and simply say, number 1, continuation application accepted or granted. Number 2, discharge application refused. Number 3, costs.
Yes. All right. Well, I think I probably have enough for now.
Very good. Thank you. All right. And then that brings me to the position in relation to Byju Raveendran and Divya Gokulnath. The claimant seeks continuation of the freezing orders against both of those defendants, and the defendants cross-apply for discharge, alternatively fortification. And the claimant, in addition, the claimant essentially makes the same application for disclosure that succeeded against Byju Raveendran at the last hearing. We've had nothing substantive from them since they obtained an adjournment. The last email that we had was for organising this hearing. That was on the 18th of September, and then Altamimi came off the record on the 10th of October. And until this morning, we'd had nothing further really about this hearing. Your Honour will recall that the adjournment was granted on the basis that they said they needed time to produce further evidence, and they have not done so. And so we are very much no further than we would otherwise have been had you heard this at the original return date. The application notice that was issued for challenging continuation and for discharge doesn't tell us much. It doesn't set out the grounds. So you have it. It's at page 828 and 829. I think they simply say, for the reasons set out in their evidence, they apply for discharge. The reasons are then set out in the first witness statement of Ms. Jabala, which is at page 6248.
Sorry, what page?
6248.
Thank you.
And the grounds are summarised at paragraph 7, which you will find at page 6250. And so they say under the various headings, there's no good arguable case, so there's no risk of dissipation, so it's not just inconvenient, and then they have full and frank disclosure points. So just to break those down, paragraph 8, the good arguable case, what do they say? They say there is no good arguable case that 1, the claimant will obtain a judgment in the US, and 2, that any judgment will be enforceable in the DIFC. So just starting briefly with why the defendants say the claims against them in the US will not succeed. And if you go over the page in Ms. Jabala's statement at page 86251, and so now in paragraph 9, at the end of that paragraph, you'll see what the first thing they say. The defendants contend that they have never been properly served with the Delaware complaint, so they take a service point. Second, you can see this at paragraph 14. They say, this is over the page 6252, they say that the US court does not have jurisdiction over them, and they rely on 2 statements from Mr. Matthew Draper in the US proceedings. I don't know if you can see that. So that's as much development as we get here. Mr. Draper's conclusion about jurisdiction in relation to Ms. Gokulnath, sorry, is at page 6234. And paragraph 21 of his statement, you see that he says Delaware court lacks jurisdiction over Ms. Gokulnath, and it gives various arguments for why that is the position. And then in relation to Mr. Byju Raveendran, we have that in his second witness statement, which you find page 6235, but the relevant section is 6245. And then he sets out his analysis of the US law governing jurisdiction, and essentially the points are, and you see this at the top of page 6246, end of that line, if it's correct that service was not correct under UA law, then there was no service and the Delaware court lacks jurisdiction. So they take a service point about the service in the UAE, and then the main substantive jurisdiction complaints at paragraph 42. And they say, second line down, Byju, there's no jurisdiction over Byju Raveendran because he lacks a substantial connection with the forum. And further down, if you look at paragraph 44, the punchline really is second line, paragraph 44, Byju Raveendran was not a director or employee of any Delaware entities, and then concludes that there's a lack of jurisdiction. Now, we provided this court with quite a bit of detailed evidence of US law in our responsive evidence. I'm going to give you the reference to it, but I'm not going to take you to it because there's a shortcut to all of this, which is a recent decision from the US court. So in case you wish to look at it, it's quite complicated, but Mr. Hurinsky's first witness statement, which starts at page 6636, and we summarize the position in our skeleton argument as well. I should have started by saying we're now looking at 2 different skeleton arguments. I don't know if you've got those to hand, and it might be worth finding those in due course. We don't necessarily need to look at it right now.
This is the skeleton argument described as skeleton argument on behalf of the oh no, that was in relation to the collateral use application.
So we'll need to look at the collateral use skeleton later on because there's some bits of that are relevant, but it's called claimant skeleton argument hearing on 24 to 26th of November 2025. So that was filed in relation specifically to this hearing.
What was the date of that one?
The date would have,
Would
the date
have
was 17th
expired.
November. 17th of November.
Right.
Just wondering if it's got its way into the bundle.
I was just going to download it separately, but as luck would have it, it's taking a time. Is it in the bundle?
I'm not sure it's
All
in
right,
the bundle.
I'll find
Sorry.
it on the portal, might be easier. Did you say the 17th of November?
Correct.
It's not on the portal.
Ah.
For some
Please,
reason.
can I, if I may, I'm just ask my team to make sure that we
Yes.
send another copy, please, to the registry.
The registry, yes, please.
And they'll, I think I don't need to show it to you right this second, because
All
I
right.
think, as I say, we'll hopefully that'll come through fairly shortly.
Yes.
But essentially, the evidence sort of joined issue on these points about service and substantial connection, and some fairly technical points about the federal rules of civil procedure. But there was quite a bit of explanation as to why the assertions were wrong. And the question at this stage, at least, was simply, is there a good arguable case in relation to these issues? And the answer to that we now have authoritatively, because we have the US court decision of the 20th of November 2025, and that in that decision, the US court dismissed these service and jurisdiction objections in relation to both Divya and Byju. I'll come on to that in a moment, but just to complete the story about what is being said against us. The third thing that the defendant said is that the claimant's evidence for the ex parte hearing didn't establish a good arguable case on the merits in the United States. That's at page 6252. And paragraph 13. These points were not developed, but one of the points that was made there was that Ms. Jabalova said that the defendants were not going to provide any evidence about what their case will be in the United States. And they said that if they were to do so, that might somehow prejudice their rights in the United States proceedings. They don't explain that. We don't accept it, but there we have it. Now, the recent developments are dealt with in Mr. Horinsky's sixth witness statement, which is dated 21st of November 2025. It's very recent.
Yes,
and essentially, I'm grateful. So if your honour was to go to page 11236.
Well, I'm looking at it as a separate. I've got it, the PDF separately.
Well, that's even better, because so am I. So if your honour was to turn to the third page of the PDF, you will see at the top right DHH7/1, and I'll give you page numbers by reference to that if it's convenient for you.
Okay.
But the first is a judgment of the US court, or an order of the US court, dismissing the defendant's motion to dismiss. And that was a motion to dismiss that advanced 3 grounds. And you see what they are if we go forward to page 3. So DHH7, page 3. It's page 5 of the PDF, I think. And you'll see in the middle, defendants Raveendran and Gokulnath, the moving defendants, have filed a motion to dismiss the complaint on 3 separate grounds. First, that the debtor has failed to properly serve them with the summons and complaint. Second, that the court lacks personal jurisdiction over them. And finally, that the complaint fails to state valid claims against them. And so the court looks at all 3 of these issues, which are all the issues that are raised against me in this hearing. And if we go forward to page 14 of the exhibit, so DHH7/14, and you'll see that's page 13 of the judgment. And at the end of an analysis, they find the second paragraph, this court finds that the thorough analysis and rationale of Harris is applicable here. The complaint alleges that Raveendran served in the officer role of the CO to the debtor, and the transfer agreement supports those allegations. Accordingly, the debtor has met the burden of demonstrating that Raveendran is subject to the Delaware consent statute and service of process upon Raveendran is proper in this matter. So that's Byju Raveendran by himself. Was properly served otherwise because he was a director. And then if we go to page 17 of this exhibit, you will see in relation to both, they consider the question in relation to both defendants, and they say it's about 6 lines, the end of 6 lines down from the top. The record before the court demonstrates that the debtor's service substantially complied.
What page are you on?
So DHH 7/17. 17.
Yes.
So it's page 16 of the judgment.
Yes, I have.
Thank you. And about 6 lines down from the top, at the end of that line, the record before the court demonstrates that the debtor's service substantially complied with UA law and was reasonably calculated to and did provide notice to the moving defendants. So they dismissed that first part of the allegation, which is that service of the UAE was improper. And then if we go forward to page 22, so DHH 7/22, which is page 21 of the judgment, they deal with this second point, which is the allegation that the court had no personal jurisdiction and reject it. So to summarize, if you have that first main full paragraph, Raveendran's execution of the transfer agreement as CEO of a Delaware corporation is a substantial forum contact that stripped the debtor of assets and ensured those assets were beyond the reach of the debtor and its creditors. This purposefully directed action resulted in alleged harms underlying the claims in the complaint. Accordingly, the court has specific in personam jurisdiction over Raveendran. And the other ground, which applied to both defendants, was that in essence, the effects of a tort that they both committed were felt within the jurisdiction. And that's essentially called the effects ground. And they consider that at page 25 and find that the test is satisfied. And you can see at page 20, bear with me, page 26.
Yes.
In the middle of the page is the punchline on this one, which says, accordingly, this court may exercise personal jurisdiction against the moving defendants for the intentional tort claims under the effects test. And they go on and accept another ground subsequently in relation to the conspiracy test, which is on page DHH 27 over the page. And it's the last 5 lines. The plaintiffs have shown that they conspired to defraud creditors with co-conspirators who had substantial contacts with this forum by directing fraudulent activity using Delaware entities and harming US creditors. Accordingly, the moving defendants are also subject to personal jurisdiction under the conspiracy theory test. So personal jurisdiction was established on multiple grounds. And then the third aspect of good arguable case in the US proceedings, the arguability of the claims under US law. This motion to dismiss recites the defendant's case that the complaints against them should be dismissed for failure to state a claim upon which relief can be granted. You can see that analysis starts at the top of page DHH 7/28. And you will see there they set out the test, and it's not dissimilar to the summary or the immediate judgment test that we have. If one looks through that.
Maybe I haven't read this carefully enough, but isn't the effect of it that the pleaded allegations are capable of giving rise to the claim, but they don't determine whether or not the pleaded allegations are supported by sufficient evidence.
That is the same as the test in our courts, in the sense that if I plead out a particulars of claim and sign it with a statement of truth,
yes,
then those facts.
Was the complaint in this case had the equivalent of a statement of truth?
That's a good question. I'm not sure if that is right. Bear with me one moment, if I may.
Yes.
The Second Amendment complaint, I don't know if that is right. I think, though, that what we would say, and I'm going to see if someone will help me with that, but thank you. I think when you look at why they say that it is reasonably arguable, essentially, like most fraud claims, what they're doing is they're taking the primary facts that are known and can be established directly.
That's what I was putting to you. You probably read it more carefully than me, but I thought what they were doing was taking the pleaded allegations and then determining whether or not those pleaded allegations, if correct, give rise to a claim, but make no determination on whether or not the pleaded allegations are in fact supported by evidence.
I think that's right, but I think what they're doing is they're essentially finding out whether or not, on the basis of the pleaded allegations, there's a sufficiently arguable inference that can be drawn. So if we go to bundle DHH 7 tab 28, if you're still there, it's and then go through. So on count 1 at 28 to 30, they go through an explanation of why there's a sufficiently arguable case against the defendants for aiding and abetting Ryju's breach of fiduciary duties. So they say support a claim, and they set out the elements that are required. If you see that, existence of a fiduciary relationship, breach of fiduciary duty, knowing participation, breach by the defendants, and damages, and so forth. And they say the courts previously determined that Ryju is liable for breaching his fiduciary duties. So I mean that's why I said I think that they start from facts which perhaps aren't necessarily in dispute, or facts which are asserted. But they say the only factor in dispute is the moving defendant's knowing participation in the breach. Then they set out the test for that. Then they explain what the complaint is. And this is on page 29 now. The moving defendants argue that the complaint cannot support a claim against them for aiding and abetting Ryju's breach of fiduciary duty because there are only 2 members of TNL's board and did not have authority to direct Ryju. And then they just say that they are also argue that TNL owed the debtor through a subsidiary, thereby further distancing distancing TNL. But then they say, but the complaint alleges sufficient facts from which the court can infer that the moving defendants knowingly participated in the breach of duties, including that 1, Ryju, although the debtor's sole director testified that he made no decisions on his own, including decisions related to the first fraudulent transfers, and 2, when asked who specifically at TNL directed his actions, Ryju identified Raveendran and Gokulnath. So what I'm saying is that they're not relying on what they would describe as conclusory allegations of dishonesty, and saying, well, because it's been asserted, that conclusion has been asserted, that's sufficient. What they're saying is that the facts which are relied on are sufficient to support an inference of fraud in this case, on their view. That's my reading of the judgment. So it's not quite as thin as it might be if it was just pure pleading. They're relying on an inferential case that they build from these facts. And I mean, in a sense, only one of these is necessary at all to support the claim, because it's a freezing order. But they go on with each count to do a similar exercise. So when you look at page 30.
So in relation to that first one,
yes,
Montague Smith, we're looking at what is called count 1. The facts which the court finds would be sufficient are that Byju, through the director, sole director, made no decisions on his own. And in relation to that, there's not just a pleading, but there is evidence that Byju said that. And secondly, the second part, again, there's evidence that T&L directed his actions. So I think that's right. They're identifying not just pleading, but evidence which supports those facts which are necessary to make out the case. Yeah.
Yes, and I think that the way that the pleading works is unlike our sort of bare bones English approach. It's more towards the
it's like a novel, isn't it?
Well, that might be interpreted as being somewhat pejorative, but it certainly tells a story in a more comprehensive way than we do in our bare bones pleadings. I think that's right. So I think
perhaps I should say it's a more narrative form.
Yes, I think that. I don't think. I don't. Yeah, I'm told that there is no equivalent to a statement of truth, but it is signed by counsel. But as I say, it incorporates. So, for example, the screenshot of the piece of paper which recorded the bankers listening to Mr. Byju saying the money will find. You'll never find it. Someplace you'll never find it. Right. But I think the critical thing is I don't think it's disputed that Byju testified that he made those decisions on his own, and it's not disputed that when asked, he specifically identified Raveendran and Gokulath. And then we have made out in our skeleton argument more detailed submissions in relation to this, but this is not the only development, and so I think the question is it sufficient? Is there sufficient to say that this is going to go off to trial, and is there therefore a reasonable chance of this being successful? And I think we would say at this stage that it might, whether it's a similar or different test, is a little bit by the by. The point is that the US courts have said there's enough here. There's enough here on each of these counts for us to say, yes, we may well find at the end of the day that that there is a fraud in here. And they've done that in relation to each of the counts where it was disputed. Any one of those would be sufficient, we would say, to support the freezing order, because the freezing order is simply an order that requires, when it comes to good arguable case, a reasonably arguable case that they will ultimately be liable for a certain amount of money. So we do say that this dispenses clearly with the service points. It dispenses with the jurisdiction points. Yeah. Does it dispense with the good arguable case point? We say yes, but this is not the end of it. There is more. You may also have seen that when it comes to Byju Raveendran, he is now, there's been a default judgment against him. And so he is at the moment now liable for the money that's been ordered against him. Yes. That is, you'll find that at page 43 of this document. Now, I say it's been ordered against him. There is a judgment against him, but the order is not yet complete. That will come, but it will simply follow on from the judgment. So the judgment starts at page 43, which is the opinion granting plaintiff's motion for default. It's not default judgment in the sense of you failed to respond to the claim. It's default judgment in the sense that he has defaulted on orders for disclosure. Yeah. And as a result of that, judgment has been entered against him. And we would say, if you want to read this, you will see that it is what we would describe as a pretty careful and detailed judgment explaining why default judgment was appropriate. And it orders default judgment against him on some grounds in the sum of $533 million and others for $540 million. Obviously, they're not cumulative. And so if you go to page 64 of the exhibit, which is the conclusion,
Yes.
Page 22 of the judgment, that sets out what will be ordered against him. So the court acknowledges, so for the reasons set forth above, the court will enter default judgment against Raveendran, defendant Raveendran, count 1, and then sets out the other counts together with interest. So that there will be an order in due course. You will see the court acknowledges that the relief granted is extraordinary, but the circumstances of this case are frankly unique and unlike anything the undersigned has encountered before, thereby making such relief in this case richly warranted. And I'll come back to why ultimately in due course. But if you go over the page to page 65, you will see that the parties are requested to confer and submit a proposed judgment order within 7 days. We haven't got there yet because this is dated the 20th of November. So this was just on Thursday that this was released. So as against Mr. Byju Raveendran, this goes to the question, is there a good arguable case that at the end of the day we will have a judgment against him? And unless something radical changes in his attitude towards that court, it's looking highly likely that we will, because we have one now. And then the final development, which occurred just shortly prior to this hearing, was that we obtained a declaration from Mr. Oliver Chapman, who is the CEO of OCI, and that is dated 15th of November. And he effectively takes the lid off and says, well, yes, the money that was received by OCI was not received for the purposes that Byju Raveendran has said it was received for. And that declaration appears in DHH 6, if you have that separately as well. I've got a bundle reference for it.
I think I want the bundle for that one.
Fine, that's on page 11206, Fred. Now, this was submitted to the United States Court as part of a settlement agreement between OCI and the claimants.
Yes.
And so what you have is the motion, which appears at page 11206. Do you have that? It's DHH 6/1.
Yes.
And then if you can see what this is all about, if you go over the page in the submission, paragraph 2 of this motion to the US court is a potentially useful reminder of what the case had been. 4 lines down, Raveendran repeatedly represented that the money actually had been sent to OCI for legitimate commercial purposes, namely to procure services to TNL and its subsidiaries in relation to the procurement of IT equipment, such as electronic tablets and advertising, including marketing via various media. And then on page 11220, which is page 15 of the exhibit, you get the declaration itself.
Yes.
And then you will see over the page on page 16 of the exhibit, paragraph 3, Mr. Chapman accepts that about $506 million was received by OCI. And then paragraph 4, he describes how a part of it, but a relatively small part of it, went to suppliers Google and Sony. And then paragraph 5, the balance, the lion's share of it, went to a company called Revere Master SPV LLC. And he explains who that is over the page on page 17 of the exhibit, paragraph 6, as a special purpose vehicle of Revere Securities LLP, who provide investment banking and wealth management services. And then paragraph 7, related documents in OCI's possession have been reviewed that demonstrate the intention of those controlling these funds was that almost all would be to be transferred on from that recipient to a Singapore corporation, Byju's Global Pte Limited. And then paragraph 8 $13 million went to Mr. Rupen Banker, who was the person at OCI who directed these transfers. So it looks like, and what we would say is happening, is that Mr. Rupen Banker has agreed to allow OCI to be used to launder these funds in exchange for personal enrichment. And you see at paragraph 9, Mr. Chapman confirms that OCI did not use the Alpha funds to provide outsourced procurement services to TNL. So we have it now from the horse's mouth, as it were, as the fraud starts to fall apart. The allegation that these funds were used for legitimate purposes, OCI itself says that's false. So, if the question is, do we have a good arguable case to show that Mr. Byju Raveendran did this? We do. And then we would say, finally, although it's probably unnecessary now, in the court, we say, in the court, in light of the US court's judgment on the motion to dismiss, our skeleton argument for this hearing sets out various bases on which we say there is a good arguable case. Now, I don't know whether you've received that yet. I was hoping it would be sent to you.
No, that's not come through yet.
I
think. Oh, wait a minute. Yes, I do have that. Thank you.
Excellent. Thank you very much. So we set out in a bit of detail at paragraph 23 of that why we said that there's a factual case to answer.
Oh, sorry, this is your skeleton argument.
Sorry, yes, it is. Yes.
Yes, sorry, I have read this. I've misunderstood. I thought there was one that had somehow come through from Byju.
No, there isn't.
No, that's all right. Okay.
Cross purposes. Apologies if I wasn't being clear about that. No, I was referring to my skeleton as a bit of shorthand, really. And so what I was saying is we've got the motion to dismiss judgment, which we say one way or another says there's some arguable case out there. I hear what you say about maybe it's a slightly different test, but we don't consider that makes a difference to the way the court approached it. But anyway, we've now got the default judgment against Byju Raveendran. We've got the Chapman Declaration, which just clearly shows that this money is at least strongly arguably fraudulently stolen. And then we had set out before we even got there what we say in paragraph 23, because all of those documents I've shown you post-date this skeleton, as to why we say there's a strong inferential case of fraud. And there's some, essentially some quite detailed forensic points that we say just give rise to at least an arguable inference that both of these defendants have participated in a fraud. Amongst them, this was directed by TNL, and they were both on the board of TNL. When ordered to find out what had happened to the money, Mr. Raveendran turned to Mr. Byju Raveendran, turned to Mr. Byju Raveendran and Ms. Golkanath, which indicates that they were the ones who instructed him, and they were participating in those instructions. And you'll recall Mr. Byju Raveendran, he denies it, has said the money's somewhere, lenders will never find it. And they were all living together in the lap of luxury, living, we would say, clearly off the same funds, which one would see a strong inference being that they were all enjoying the proceeds of fraud. And Your Honour may recall in the Haler Declaration, there's talk of a sum of $11.25 million, which found its way to Mr. Haler and then went back again when he became nervous about its source. And it went back again via Ms. Golkanath's bank account. So we say that the natural inference is that essentially these people who claim to be penniless but live a rich lifestyle, this is stolen money, which it very much appears to be. Then they are living off that money, all of them, and that includes all three of them. So we do say that there is very strong evidence against all three of them, and the idea that there is no good arguable case makes it's just a very difficult argument to put together. Now, what about if we get judgment out of the US court? What happens to it then? And we have got judgment in relation to Mr. Byju Raveendran. So the second point that is made in Ms. Jabala's statement is they say, well, the claimant doesn't have a good arguable case that any US judgment will be enforceable in the DIFC. That's never been developed by the defendants. And you'll recall when the court issued the injunction, we made a couple of arguments about this. In fact, we made, I think, 4. And Your Honour accepted 2 were at least reasonably arguable. We see that at page 152 in the transcript. But just to remind you what you said, if you can't remember, I wouldn't blame you for an instant, given how long ago that was. But I think your position was, firstly, it is well arguable that the DIFC court should now adopt a test which is sort of reflective, if I can put it like that. In other words, would the DIFC court accept jurisdiction in equivalent circumstances? And the second point you made was that the defendants might yet submit. There were a number of other points. We raised those. We relied on model law enforcement. We said that in relation to Mr. Byju Raveendran, he submitted by acting as a de facto director. You didn't feel the need to deal with those, and we can understand why. We would just say that nothing has been said by Byju or Ms. Gulkanath which would shake your view that these are at least reasonably arguable. They've literally said nothing about them other than to assert that there's no good arguable case on enforcement. So in relation to enforcement after that, I think what they're getting at is to say there's no jurisdiction. That must be what they're getting at, because the case at that, when they said those things, had not progressed beyond being started, and so there couldn't really be any other defences that would arise, like natural justice or fraud or anything like that. So clearly it's possible that they might come up with some other defences. And the one thing that stands out, if this was an ex parte application, I'd be saying, drawing your attention to the fact that the default judgment against Byju Raveendran, it might be said that that was unfair. We say that shouldn't trouble Your Honour. Why? Because the court's decision against him was a result of him and his gross disregard for the US court's orders. I think the point we made last time, and it remains the case, is that the proper exercise of the court's powers to sanction a party doesn't give rise to a defence. And we explained that in our ex parte skeleton in relation to Mr. Byju Raveendran. Of course, at that stage, we didn't have a default judgment against Mr. Byju Raveendran, but the same principles at least apply. And what you have in that default judgment motion to dismiss opinion it is a careful consideration of the applicable test in the US court. I can take Your Honour through it.
Does that motion amount to a submission to jurisdiction?
It may do. I mean, it may do, and I think there's going to be arguable. There would be arguments to be had about that. I think his part. You mean his participation in the motion? So there were two parts to it. One, yeah, it could well do. It will depend. I'm not in a position to sort of put that all out in front of you because this stuff came in very late last week. So we don't want to muddy the water by bringing in new evidence, which might have prompted a new application to adjourn and all the rest of it. I think at this stage, I think it's just illustrative of the fact that going forward, there will there will be opportunities for the defendants to engage with the courts, which may be arguably submission of one form or another. Now, that may already have happened. It may happen in the future. And I think that cluster of points really was your second reason for saying it's at least arguable that there is or will be submission. But in relation to the sort of, on reflection, I'm not going to go through this in any real detail. If Your Honour wants me to, I'll take you through it, but it's in DHH7, and you will see how the court approaches this at pages 49 of DHH7 and onwards. But ultimately, there's a test that's set out in the US courts about whether it's appropriate to enter default judgment, and the judge goes through all of those bits, and then at the end, on page 58 of that document, the judge steps back from it all and says, I now need to effectively sense check this. And you'll see at the bottom, there's an additional check on the court's exercise of discretion that requires the court to determine that the sanction is just, and the sanction is specifically related to the claims at issue. These limitations are rooted in notions of due process. So the whole exercise is not some sort of mechanical box ticking one. It's to ask the question, is it fair to allow the defence to continue in the circumstances, or is it fair to enter judgment in these circumstances? No doubt it may be said in due course that that was all terribly, terribly unfair, and we will have to deal with that, but that would be a defence on the merits. So that's the really dealing with good arguable case. There's obviously more to be said, but hopefully that's sufficient for your purposes for today. And if there is any more that you're concerned about, it's pretty much all there in paragraph 23 of our skeleton where we've set it out in a bit of detail. But then you overlay the recent developments. Risk of dissipation. And the court was satisfied there was a risk of dissipation on the evidence at the ex parte. That's not surprising because on the facts alleged, this is a very substantial fraud claim and a brazen one, followed up by lies, and there's international elements and all the rest. And we say that since the ex parte, the defendant's behaviour has only reinforced the risk of dissipation. We deal with that in our skeleton at paragraph 29. And again, I'm not going to deal with this in too much detail, but we say, partly because this is old ground and partly because there's a lot of it. But firstly, the defendants breached the deadlines for the provision of information and affidavits. Secondly, and that in itself is another aggravating factor on risk of dissipation. Secondly, there's credible evidence that they have failed to provide proper and accurate asset disclosure. Now, Your Honour's essentially accepted that in relation to Mr. Raveendran, but most of the points raised on that application in relation to further disclosure apply equally to Mr. Byju Raveendran. Amongst them was the fact that between the three of them, they had only disclosed assets of $900,000 US. I don't know if you remember that, but the largest part of that was a single deposit held by Mr. Raveendran. And it turns out that his report of what the amount was out by an order of magnitude. So it was said to be 63 million rupees. And in fact, if you go to the bundle, page 10,003, I'm afraid. I'm going to stop apologising for the size of the bundle now.
No.
Otherwise, it's going to go on for a long time. But his
sorry,
asset
that caused me to forget the page you're referring to. What page number?
10,003. So in his asset disclosure, he'd asserted that he had a balance of 63,080,000 rupees and a bit. And in fact, if you look at, this is his bank statement that he's disclosed. If you look on the entry for the 23rd of April, you'll see the actual true balance was in fact 6,308,000. So rather than having $700,000 worth of rupees in this account, he actually had about 70,000. And that meant that instead of having disclosed between them liquid assets of 900,000, actually they were disclosing something in the region of 250,000 US dollars. And if you recall, their stated expenses were $75,000 a month. That's at page 8996 in a letter from Martellini. So I mean, there are other points on this, but there is simply no way that the disclosed liquid assets could explain the lifestyle that they were living. There were also, the third point, the credible evidence that the defendants have breached the provisions in the freezing order concerning permitted expenditure on living expenses and requiring prior notification of the source of funds to pay for legal expenses. I mentioned previously, you were told last time that Byju had paid his DIFC lawyers nothing. That may or may not be true, given Byju Raveendran says he hasn't paid his lawyers either. But there are no lawyers here to explain what the position is currently. No one's going to tell us.
I think doesn't the letter that was sent by, I thought it was Byju Raveendran, say he hasn't paid the lawyers?
It does say he hasn't paid his DIFC lawyers. That's correct.
Yes.
Right. That may or may not be true, but has he paid his US lawyers? Has he paid? He says he's gearing up for a $2.5 billion claim against, I don't know who, possibly Tamimi now. But that's going to require paying some lawyers, one would have thought. No one, there's been no notification whatsoever of any of this. Now, maybe all his lawyers are working on credit. I wouldn't advise it, but that may be the position. But my point is that I think one can infer that in the usual course, one would have to spend money on lawyers to run the case in the way that they've been run in the US, to run to deal with the run up to a large claim for $2.5 billion. You're going to have to write a check, and there's no evidence that he hasn't done that. He hasn't said he hasn't, and so in those circumstances, you can infer that there is a reasonable prospect he's breaching the order, the notification orders. We also say he's fled the UAE. He doesn't like that characterization of what's happened, but it perhaps partly depends on whether you accept that he was living in the UAE. As we understand it, Divya Gokulnath is still in the UAE, but that's because she's subject to a passport order in the UAE and she's complaining loudly about it. So her position appears to be that she wants to leave the UAE, and we say that that is conduct in response to a freezing order, which indicates that she wants to go somewhere where she is more judgment proof. Obviously, that there are other reasons you might want to do to make that move, but in the context, these are all just factors that we say are supportive of a risk of dissipation. And there's a number of other points we raise in our skeleton argument at paragraph 72, but I'm not going to labour this. What I will focus on are the points that the defendants raise to rebut the case that there's a real risk of dissipation. If we go to page 6252, please. 6252. So we're back in Ms. Jabala's witness statement, and the relevant paragraph is paragraph 15. What they say there, and I will summarise, but at A, they say that the relevant events took place a long time ago, by which they mean 2022 and 2023. You see that in A. And second, they say that the events have been subject of public litigation in other jurisdictions. Now, we address this in a bit of detail in our skeleton argument at paragraphs 31 to 35. But the short answer to all of this is we say it's the application in this court which triggers the immediate risk, as is always the case with freezing orders. You can't tell people that the question is not whether the application should be brought on quickly. The question is really one about full and frank disclosure. About ex parte and whether it should be done ex parte. But the problem, of course, is the minute you tell somebody you're making the application, that is when they're most likely to move the money. And there is also evidence out there that until this action, the defendants felt that they were safe in Dubai from any action. And indeed, in Mr. Hayler's declaration, he reports Mr. Byju Raveendran telling him that that is the case. And that's if you want to see it, it's page 2318 of the bundle. But where Mr. Hayler said that. So there's other technical points about whether or not delay means there's no risk of full and frank disclosure. Sorry, delay means there's no risk of dissipation. There's also points about delay in the context of full and frank disclosure, and I'll come back to that if I may, just to sort of silo the issues. But we would say there is and remains a risk of dissipation, a real risk of dissipation for any number of reasons, but mostly for the ones that I've suggested to your honour. And then the question becomes, is it just and convenient to continue the freezing order? And they say that it is not. They don't challenge our analysis of the factors which are traditionally taken into account in that. But just pause before we go into embark on this exercise. If you accept that there is a good arguable case for that there was a fraud of 530 million, it seems to us that everything really follows from that, and one can cut it up into tiny little issues, but ultimately most courts would be content that there's a fraud claim, that they're likely sitting on at least some of the proceeds of that fraud, and that makes it both a risk of dissipation and also just and convenient to make a freezing order. But what the traditional factors that come into play are, we set them out, but they're paragraph 36, we set them out: the strength and of the underlying claim, the size of the claim, whether relief would be effective, potential disruption to the defendant's business, and the conduct of the claimant in relation to the application itself and the underlying claim. And the defendants rely on 4 arguments to say it's not just inconvenient. And you see this, if you're still in Ms. Jabala's statement, it's over the page at paragraph 17, it starts, page 6253. And they say, just under the heading just inconvenient, they say, firstly, the claimant's delayed in bringing the freezing order application. So they run delay in 3 different ways. First is risk of dissipation, second under the heading just inconvenient, and third under full and frank disclosure. We say there's no material delay, and even if there was delay, it would be legally irrelevant once the court's found there's a risk of dissipation. Now we've set this out in a bit of detail in paragraphs 38 to 41 of our skeleton, but just to give you the potted highlights. The defendants were in control of the claimant until March 2023. So there's no delay. There can't be any delay prior to that. The facts only then came to light gradually after that. And then by September 2023, so within 6 months, Sandra Holding was in place. And then it's in November 2024 that Carmen arrived and made this sort of application possible again. And by then, the claimant was waiting for judgment against Byju, you may recall, and it was expected imminently because there'd been a bit of a delay up to then. And ultimately, that arrived at the end of February 2025, and then this application was made 6 weeks after that, effectively. So we say that is not a delay at all, frankly. There's quite a lot of work to do, and the sheer volume of material to make sure that we gave you a full and frank picture of what was quite a complex history by that point. So we say there is no delay, but if there was a delay, that would not in and of itself be a reason to refuse relief. Ordinarily, the court's approach, we say, would be to ask itself the question, is there a risk of dissipation? Does delay mean that there is now no risk of dissipation? And if the effect of delay is that, then the court might refuse relief. In practice, we say the court takes a pretty pragmatic view of these sorts of things and says, well, if there's anything left, it's worth shutting the stable door. And then stories of ponies and things in Sir Jeremy Cook's analogy follow from that. But the second thing then that they say, and we're still on paragraph 18 now, same page, paragraph 18A, is they say that the defendants So they lack substantial assets generally, and in the DIFC in particular. So as to the relevance of DIFC assets, it's not a reason not to grant an order. We say it is obviously false that the defendants don't have substantial assets generally, and the DIFC is an appropriate forum for the application. They do, except that they have at least some assets in the UAE. But as I say, fundamentally, if there's an arguable case that they, between them, have stolen $500 million, then there is an arguable case that they have a substantial chunk of money somewhere, which would be responsive to this order. Third, and this is paragraph over the page, paragraph 20, sorry, it's page 6255 now, over the page, paragraph 20A, they allege that the claimant misused the freezing order to obtain a travel ban in the local courts. That is not accurate for two reasons. Firstly, the claimant did not obtain the travel ban on the basis of the enforcement of the freezing order. So it is not the case that the claimants took the freezing order and enforced it in part by obtaining a travel ban, which appeared to be the way that it was put. And you have evidence from Mr. El-Ghattit of OGH Law, who gives who explains this. You can see that at page 6680. And 6681, where he explains how we went about, how the claimant went about this. And at paragraph 46 in particular, he explains that this was not an exercise in executing the DIFC court order. It's hard to see how it could be, given that the DIFC court order says nothing about passports or travel bans or anything like that. I'll come back to the other allegations because, again, the complaint about the travel ban is reused as a full and frank disclosure complaint, and I'll come back to it in that context. But the fourth complaint, just on this front, we see that at 6255 again, which is Ms. Jabala's statement, and it's paragraph 20B. The Part 8 defendants' bank accounts from which their living expenses are being paid have been frozen entirely with a lien on those accounts. And so that, it was said, was a reason why it's not just inconvenient to continue the order. But 2 points. Firstly, there appears to have been hardly anything in those accounts anywhere, or at least hardly anything that's being disclosed. So if they were truly being used to fund living expenses, that must have just been a device that must have been topped up from other sources. So there are then those other sources which are being used to fund the living expenses. And the other point is a more procedural one, which is that they made no attempt to try to resolve this. And it's a matter of fact that when this court makes freezing orders, the way they are executed onshore can cause problems for parties because they can lock down accounts and prevent transactions which would otherwise be permissible within the terms of the order. Now, that can happen in London. It's right that it happens perhaps with more frequency in the DIFC in Dubai, but the answer to it is to try to talk to the lawyers to reach some sort of solution. But having said there's this problem, they've never reached out to say, let's solve it. But the central point really is that they probably, one can infer, they don't actually need these accounts because they've been, it appears, paying their living expenses without the benefit of them, and there was nothing in them anyway. So that is it on just and convenient, and that leaves, in relation to this, just full and frank disclosure and fortification. I won't go back to the principles of full and frank disclosure, but there are 5 full and frank points raised against us by Mr. Byju and Divya. Those appear at 6256, And you see them at paragraph 22. And the first one is the admissibility of the Ryju US summary judgment. And this appeared to be their central point, really. They say, in effect, that we should have told Your Honour at the ex parte hearing that the Ryju summary judgment findings were inadmissible in these proceedings. And they rely on the rule in Hollington and Hewthorne, which restricts the use that can be made of certain sorts of findings at trial. Now, I should say to Your Honour, I'm afraid it did not occur to me or any other member of the claimant's legal team that the defendants might say this. And we say that is for good reason, because the rule in Hollington and Hewthorne has no application in the context that we are dealing with. And we say that because the English Court of Appeal has said that. So even if we're applying straightforward English rules of evidence, then this rule just has no application. And that is the Mex Group and Ford decision. I can't show you the authority because you haven't got the bundle access, but I can give you quite a short passage of it, actually. It's page 1956 of the claimant's authorities bundle.
I do have the bundle now.
Oh, you do?
So Leah
Excellent.
got it for me during the break.
Perfect. Thank you. So that is paragraph, so it's page 1956 of the authorities bundle for the claimant, and paragraph 28. And you'll see there the argument that was being run by Mr. Calfon for the HK defendants, submitting that these judgments of Lord Sanderson are inadmissible in accordance with the rule in Hollington and Hewthorne, as reformulated and explained by the Court of Appeal in Rogers and Hoyle. And they recite and explain what that is. As the judge rightly recognised, the foundation on which the rule must now rest is that findings of fact made by another decision maker are not to be admitted in a subsequent trial, because the decision at that trial is to be made by the judge appointed to hear it, the trial judge, and not another. The trial judge must decide the case for himself on the evidence that he receives and in the light of the submissions on that evidence made to him. To admit evidence of the findings of fact of another person, however distinguished and however thorough and competent his examination of the issues may have been, risks the decision being made, at least in part, on evidence other than that which the trial judge has heard, and in reliance on the opinion of someone who is neither the relevant decision maker nor an expert in any relevant discipline of the decision making, of which the decision making is not one. The opinion of someone who is not the trial judge is therefore, as a matter of law, irrelevant and not one to which you ought to have regard. And then, in essence, as the judge rightly said, the foundation of the rule must be the preservation of the fairness of a trial in which the decision is entrusted to the trial judge alone. And then paragraph 29, in my judgment, this rule has no bearing on the present issue. It's concerned with the findings of fact at a trial. These English proceedings have not reached the stage of the trial, and because they are ancillary to the substantive proceedings in Scotland, never will. It would be absurd for this court to shut its eyes to developments in the Scottish proceedings to which these English proceedings are ancillary. So essentially, where you're never going to have a trial, the rule doesn't apply because it's all about the sanctity of trial decision making. And just as in this case, in the next case, the DIFC court can give whatever weight it likes to the findings and related proceedings in the US court. Now, we've made this point slightly on the cuff, off the cuff, sorry, on the hoof, at one of the return days, because it was being pressed quite hard, and we pointed out that it was a bit rich that they were bringing this principle to the court's attention, saying we hadn't told you about it and making great complaint about it when it had been considered in the Mex Group worldwide case and said not to apply in this context. And rather than withdraw it, what they say is this, just going back to page 6256 of the bundle, they say, about 7 lines up from the bottom of 22A, even if, as the claimant indicated at the directions hearing on the 25th of June 2025, his position is that an exception to that principle articulated in English judgment applies in an interlocutory context, then the duty of fair presentation and full and frank disclosure still required the claimant to identify the principle and the relevant authorities and explain why the exception applied. And then we would say, rather overstate the importance that we placed on the partial summary judgment. And the short answer to that is, if you're with me that the rule doesn't apply, then I don't need to tell you about rules that don't apply. Whether you characterize it as an exception, which is a slightly tendentious way of saying the rule applies, but there's an exception, or whether you say the rule just doesn't apply. If I have to tell you about all the rules that could apply in a case but don't apply, then ex parte hearings will get quite lengthy. So there's nothing in that one. The second one,
I think you would only be obliged to tell me if it was arguable that the rule did apply.
I think that's right. And I don't see anybody explaining to you why it's arguable in this context.
No.
So there we are. But I mean, even if it was arguable that it might apply, is that the sort of thing that you would say, all bets are off, let's get rid of this injunction? This is a, I have to say, I mean, in those circumstances, the question is how arguable, because you would not expect me to bring forward everything that might conceivably be thought of. And if I didn't, and even if you thought I would have done it, then the sanction might not be, it might just be a bit of a public censure for me for not having anticipated something that was properly arguable. But it wouldn't have changed the dynamic. It wouldn't have changed the analysis in any real meaningful way. So the second point then, paragraph 22b, is the evidential, about complaints about the evidential basis for the claims. And this, we have to say, is pretty vague. I mean, I'll allow you to read it if you haven't already, but what is said is that the claimant did not fairly or accurately at the without notice hearing identify the evidential basis for the claims against each of the Part 8 defendants separately in addressing good arguable case. And they complain about the evidence and then say, next page, a fair presentation of the application required the claimant to clearly identify matters which, well, something's gone wrong here. I think it's saying clearly identify which matters were evidenced and which were not, and to perform the exercise in relation to each defendant separately. We don't accept that as a fair criticism. We don't accept that is even really capable of answer. What we did at the ex parte hearing is refer, Your Excellency, in detail to the allegations made in the Byju complaint, which itself relied on evidence. We showed you the evidence that we thought was appropriate and explained why in relation to each individual defendant that gave rise to a claim. I think it's difficult to say. I mean, if you are concerned about this, paragraph 23 again of our skeleton argument really sort of sets out what we say about the evidence that there was at the ex parte hearing and sets out some of the references. But fundamentally, it's impossible to tell from 22b what it is being said we should have told you but didn't tell you, or what we told you but shouldn't have told you. It is stated that there was some inaccuracy, did not fairly or accurately identify the evidential basis, but it's not said what the inaccuracies were. So really, it's quite difficult to engage with that complaint, I'm afraid. I think I'll leave it there unless you've got concerns about that.
No, I think that's enough.
Thank you. The third one is about timing and delay, and you'll see that they say we did not fairly present the relevant considerations regarding delay in seeking relief against the Part 8 defendants, and they complain that we did not, third line down, identify the authorities relevant to considering the impact of delay. Again, they don't explain what precisely we should have told you, what we should have shown you, what authority are they talking about here. We did provide you with some authority. They say, well, that was only authority that went in their favour. But I think that the central point really is that we specifically raised with you that it was possible the defendant would make an argument based on delay, in response to this application, and you had the opportunity in your great experience of these sorts of things to consider whether in this case delay was a showstopper. We are not obliged to argue the case in any particular way. And then finally, I said 5 points, but I think there are 4. The final point is in relation to the travel ban. The defendants allege that the claimants did not make the court aware of its intention to seek to use the Part 8 WFO to obtain a travel ban in onshore Dubai, as it subsequently did, and that had we told you that we would do that, it would have affected whether you made the order or not. And there are 2 errors in this. The first is that it assumes that there was an intention to seek a travel ban at the time when we approached Your Honour for the freezing order. But in fact, the claimant's onshore lawyers were only instructed to seek travel bans after the injunction was made. And the reason for that was because there was this leak of information from the US courts. And what happened was that, given that there had been that ex parte hearing meeting about releasing us from the protective order in relation to the declaration, a report that had happened was the fact that was happened found its way into an email that went to the other side. What we had hoped to do was come before Your Honour and take some time and which would allow us to take your order and go to the relevant authorities in Dubai via the Dubai courts and lock down assets. But unfortunately, because of that leak, that wasn't possible. And so we were rather precipitated into having to serve everything quickly. And the travel ban was sought in that context. That's explained at page 6667. That's Mr. El-Ghatit's first statement, paragraphs 10 to 11. So that's the first error. And the second error in this submission is that, and I've been over this, that the claimant did not obtain the travel ban on the basis of enforcement of the freezing order. So the argument that us saying we're going to take your freezing order and use it for these purposes would have affected the question of whether you issued it just doesn't even get started, because that was not actually what happened. So there is nothing in any of those full and frank disclosure complaints either. Once again, that's it for the freezing order in terms of apart from fortification. Now, in terms of fortification, it's really the same point again, which is that there is no evidence of a good arguable case of prospective loss from the freezing order. What the defendants have done, and it's also in Ms. Jabala's statement, is that they've just referred in general terms to 3 categories of potential loss. You'll find that at page 6260. 6260, which is page 13 of Ms. Jabala's first statement. And there are 3 submissions here. The first is at paragraph 34, and there's general reference to the travel bans. However, say it again, the travel bans aren't based on the enforcement order, so we cannot be required to fortify the cross undertaking, which will respond to harm caused by the freezing order on the basis of harm which might be caused by the travel bans. In any event, there's no evidence to support actual evidence of any loss which might arise from the travel bans. So there's 2 points, 2 answers to that. The second point that is raised, paragraph 35, they refer to the onshore attachment over Ms. Gokulnath's accounts with EMBD and say, we've seen this before, that is hindering her ability to pay everyday expenses. Again, they've chosen not to file any evidence of actual loss or even explain what that loss might be. And also, we say there are clearly other sources of income. So they haven't said, for example, she needed to pay this bill and she's now being sued for it, or somebody's terminated a contract or something. It just isn't the case. So there's no good arguable case on loss from that. And then the third point, paragraph 36, refers to legal costs incurred. So they say under the heading, the defendant's evidence of loss, then they have legal costs. But legal costs of opposing continuation cannot logically be relevant losses for the purposes of fortification. Because, well, for two reasons. One is it's the wrong category of thing. It's the fortification is there to support the cross undertaking, which meets the harm caused by the order. The costs associated with that are something distinct. They're not harm caused by the order. But secondly, if Your Honour's with me and continues the order, then they're not going to get their costs. But the third point is there's no evidence of legal costs and they haven't paid them. They say in paragraph 36, 3 lines down the part, each defendants will update the court as to what they consider to be the appropriate amount of fortification to cover legal costs and other applicable expense losses closer to the hearing date. And of course, they haven't done that. So we say Your Honour should dismiss the challenge, the set-aside application, should grant the continuation application, and should refuse to order fortification. And again, we have an order in relation to these two people. Page 57 of the bundle is where we are up to. And this was your continuation of the order in light of the adjournment. The injunction shall continue until further order. So no further order, kind of rebuilding the freezing order, if I can put it like that, is required. And all that's really required probably is dismissal of the set aside, granting of the continuation, and costs. In relation to costs, we say all of the costs really should be borne by the two defendants, because, well, I won't repeat what I said previously. Safe to say that in terms of the merits of the claim, there is now very, very strong evidence that Byju, Raveendran, abetted by Divya Gokulath, stole this money. And essentially we've got the OCI CEO saying so. And in a full claim like that, particularly in the face of that sort of evidence, the sensible thing to do would have been not to drive up the costs that my clients are facing and drive up the losses, but to just agree to the, or not oppose the freezing order. Having done so, the way that they have approached this has been to insist on the adjournment, procedural applications to disentangle the two claims, which have added to the costs. And then we could have had this done in May or June, sorry, at the first return date. If this was really what was going to happen, they just weren't going to turn up. And instead, what we had was a sort of half-baked objection to continuation and then disengagement. And it's been expensive. Extremely expensive to do it this way, and that is the result of their conduct. I mean, we do have some criticisms of the way they've put the application. There are full and frank disclosure points which really shouldn't have been put the way that they were put. It's not quite as egregious, I would say, as the conduct of the claim in relation to Byju. But we do say when we're putting it all together that this is the sort of case that is outside the norm, and that the conduct of all of it really justifies an order of indemnity costs. In relation to the actual costs, we do have a statement of costs. It's pretty eye-watering, I'm afraid. It's $1.38 million for this exercise. And I don't know to what extent it would be helpful for me to go through that.
Now, what do those costs cover, Mr. Montague-Smith? Is that from the original ex parte application through till today?
I think that's right, yes.
Yeah.
And someone will tell me if I'm wrong about that, but that is right. And so it includes the whole lot. Certainly my fees are for both, for everything.
Sorry, perhaps I better just look at it. Where is that's? I've seen that. It's on the portal. Let me just have a look at that.
The only thing that is not included in that is the costs ordered as a result of adjournment, which I think you made an order in relation to. So there's no duplication there, so they've been deducted. I don't know precisely where they'll be.
Sorry, is there some allocation of the costs as between Byju Raveendran and Miss Golconith on the one hand and Riju Raveendran on the other? How's that?
Yes, there has. And so the statement of costs that you've been provided with is simply the costs related to Byju Raveendran and Divya Gokulnath. So you don't have a separate schedule for Riju Raveendran. The reason why is
I'm sorry, I misunderstood that. So that again, this is the cost for both of them, for all of them, is it?
No, sorry, 2 out of the 3. So you have you have before you a statement of cost just for.
Yes.
I know that they object to this, but I'm going to call them Byju and Divya, and I apologise to them on the transcript. We don't have the schedule for Riju. The reason for that is pragmatic. It's cost £30,000, I'm told, to get cost lawyers to draft this out and do the exercise of actually extracting line by line.
But
so
for
that's
example,
why.
in relation to council fees, has there been some attempt to split those between Riju on the one hand and Byju and Ms. Golconith on the other, given that many of them would have been in relation to both?
I'm going to check that. I'm going to check that with my solicitors. That would follow from what I've been told and what I've just told you. But let me just double check that.
Yes.
That seems to be, yes, there has been a split. So that's, I mean, it's a lot of money, but what are we talking about here? We've got the ex parte, we've got the first return date of a day, we've got the second return date of 2 days, and then the third return date of 3 days. That's a substantial commitment from all of the lawyers involved, I'm afraid. Unfortunately, that's just the way it's developed. Now, my clients have not been trying to spend more money than they've had to spend. They're trying to get some money back from this exercise, but that has been, and it may or may not prove to be of a net value to them in terms of what they finally scrape from bank accounts and all the rest in the UAE. But given that everybody was living there, it was a reasonable target to select, even though they now say they weren't. There are 2 ways you can go about this, Your Excellency. One is to try and undertake some sort of line-by-line summary determination. The other is to say, decide on principle, are you going to order as costs? Decide on the basis, are you going to order indemnity or standard costs? And then decide what to order by way of payment on account. Now, the authorities on payments on account, you may be aware of them. But one starts at 50%, but one's not tied to that, particularly where you're in a situation where the commercial value of actually going through the expense of a detailed cost assessment is unlikely to be something that people can really wear. And so in one case, in similar circumstances, the Court of Appeal adopted a sort of 70% of the total cost bill assessment on an indemnity cost basis because it was just unlikely to be economic for us to go through that process, which will be expensive. As I say, this is the product of careful analysis, and I'm told, as I tell you, that about £30,000 UK has been spent on costs of lawyers just to get this document to you. So we wouldn't want to have to go through a full-blown costs assessment if we could possibly avoid it. So I think if you're
just
not
tell me again, how could that be avoided?
Well, if you were to order a cost on account, then it'll sit there for as long as anybody, wants it to, and ultimately, if it's challenged.
So if I understand it, that the order I would make would be that there be, if I acceded to your submission that the cost you should have the cost should be on an indemnity basis, then the order I would make, wouldn't it, would be that the costs should be the subject of a detailed cost assessment on an indemnity basis, and then I would make an order for costs on account.
Correct.
Yeah, okay.
Correct. And you could do it whether you agree with me about indemnity costs or not. It's just that decision might affect the percentage that you apply.
Yes.
And the only point I'd make is, while in many contexts the temptation is to err on the side of caution by reducing that percentage, where you're in a situation like this, where you've got a party that is ultimately being forced to risk putting good money after bad, then the court has tended to be a bit more generous. That's where we would start. So I'd ask you to start around the 70% mark. Now, there is one further element to deal with today. That's all I was going to say about the freezing order, unless you've got any questions. The other element, and I was going to be quite short on this, if I may, is the further disclosure application that we have made. So the court, Your Honour's already granted effectively the same application against Mr. Ryju Raveendran, and you have set out in your judgment in relation to Ryju the principles that apply, and those are set out in your judgment at 9298. I'm not going to go through them in a huge amount of detail because you know them, because you wrote them.
I did then.
I know the feeling sometimes. It's 5 o'clock in the morning on a Monday, but yeah.
That's right.
So you've set them out, and essentially you make the point there that the disclosure ancillary to a freezing order is really critical, and it's part of the proper approach of the court to make sure that orders are made which allow the injunction to be policed. And you set out the principles there at 120 to 126. Obviously, it's got to be proportionate, but the jurisdiction exists and may be invoked where necessary to preserve the integrity of the freezing order relief. And your conclusions in relation to Byju were set out at 9302. And you grant the application, and the relevant paragraphs are 147 to 151. And in essence, we read that as saying your main issue was that there were credible concerns about the adequacy of the asset disclosure that had been given, and in particular there were inconsistencies between, this is 148, the disclosed assets and the observed expenditures and the unexplained legal funding, and all those sorts of issues. We say that all of those points apply also to Byju and Divya. I'm not going to labour this, but if you're asking the question, is there credible evidence that the asset disclosure has been inadequate? We are dealing with a case where there is strong evidence, but that between them they've stolen $500 million, and they must know where it is, and they must, on that footing, have lied about where it went, and they must not be telling us about where it is now. And we are ultimately seeking the court's assistance to make these orders effective, but that's the sort of overarching point. Now, you can't decide today, I suppose, whether or not they did in fact steal that money, but the question, that's not the test. The test is whether or not there is reason to believe that they might have done so, and might be not telling us something about pockets of cash that they've got, and that must follow. There are other more forensic points that we make, and in this context we do rely on our collateral use and further disclosure application skeleton, and we make quite a lot of points at paragraphs 71 to 92. I'm not going to burden you with traipsing through all of them, but just to pick out 2 or 3 of the highlights, if I may. First, we made the point that there was a failure to comply with deadlines. The reasons that were given were that the assets were illiquid and they didn't have time to provide a list. And compare that to what was actually disclosed. You go to page 5380, you'll see, just to remind you what Byju actually disclosed. This is it. And he disclosed only 1 liquid bank account in his asset disclosure, don't know if you recall this, it was an ICICI account, and that was one which was subject to a freezing order in Singapore. He confirmed that in his statement at page 6227, paragraph 12. So he disclosed nothing that was actually subject to his control, that was liquid, and then one real property. Paragraph, and there's some minor bank accounts which he said had substantially less than $10,000 in them. In our skeleton then at paragraph 72, we make the point about the mismatch between what has been disclosed and what they were saying, well, what we knew about their lifestyles. And as I mentioned, in all, they disclosed about $900,000 in usable cash, but most of that was in Byju Ravindran's bank account. And as I showed you a little earlier, the 63 million that he disclosed, which we see at 5373, was not 63 million, it was 6 million. So that was the main asset that they disclosed. So all in all, they disclosed about $250,000 just to complete it. So you see what Divya Gokulnath disclosed, that's at 5383. And she disclosed one bank account. But that one had barely any money in it. And you'll see that the account, the NBD account number at 4.1 matches what she says over the page at page 6 as an account having less than $10,000 in it. And as I remind you, they said their monthly expenses were $75,000. And they must have had substantial legal expenses, and there's evidence that they have a lavish lifestyle. And then at paragraph 73 of our skeleton, I've made these points in the course of this hearing in other contexts, but there was the point that they appeared, when they needed it, to have had access to substantial funds in the past, and the $11.25 million that was paid to Mr. Haler and then paid back as an example. So the end of this, I think. Oh yes, there was a section. So the way we organised the skeleton argument in relation to these applications was we had a section that dealt with issues that were common to all of the defendants, and that was what I've just told you about fell in that category. And then we had a section about Mr. Byju and a section about about Byju and Divya. At paragraph 89 of the skeleton, under that heading, we make the point that if you recall, Mr. Byju Raveendran said he borrowed money to meet his expenses. And there was a bit of concern about what was being said at the last hearing about whether or not it was understood that money that's been borrowed remains an asset, even if it has a corresponding liability. But what we would say is that there is at least the suggestion that when Mr. Byju Raveendran says he's borrowing money, he's got access to borrowing money to pay expenses, what he really means is that someone else is controlling funds which he has access to, and which he is using to pay his expenses. And then the question comes, well, what is the basis on which he has access to it? Is it, as he says, because he's getting unsecured loans from somebody? Well, not if he's bankrupt and faced with all this, or is it more likely that they're just holding his money for him? And then we say the utility of further disclosure is also supported by Byju Raveendran's disclosure, because one of the things that we found out when we saw not just that he's been spending at a prodigious rate, but it also revealed 2 undisclosed accounts, which received $2.5 million. This is the last thing I'll show you, if I may. It's just at page 10002. I showed you the page after this, but again, this is another page from his bank account. And if you look down the left-hand side, you will see on the 18th of December 2024, 2 entries, and the amounts which are withdrawn are 20 million and 200 million. And this is rupees. And that equates to in total about $2.5 million. Is that right? Sorry, this is
it's
not
rupees. 200 million. I think these are the way I forget the way they write these figures, because if you see the last 2 0, it's 2 zeros, not 3 zeros at the end. I've forgotten how the cores, those units work with Indian rupees.
Yes, no, sorry, I'm not sure this is rupees. I do apologise.
Oh, isn't it?
Is this right? Sorry, I thought I had this. No, you're right. I think it is rupees.
Yeah.
I thought this was 200 million because it's 0.00. But I see. I may be wrong.
I see what you mean. 200 million. I see what you mean. Yes.
And then above that is 20 million. So I thought that was 220 million.
I think you're right.
I see. In any event, what we can see is substantial amounts. Basically, he's drained his account in December 2024. So it's gone from 202, we think, million, but whatever, down to 2 million. So yeah. It's down to 1% of what it was before. And the destination for these payments is written down in the narration. And if you see, the first one is CLG to Raveendran Raveendran ICC Banking Corporation, and then CLG to Raveendran Raveendran and then a reference to HDFC Bank Limited. So what's happened is that he's transferred these monies to himself in other accounts. And those are not accounts that were disclosed in his asset disclosure. So that's a complaint, obviously, about Mr. Byju Raveendran, but we say that it is an illustration of the utility of these sorts of things, assuming that the order is complied with. The draft order in relation to this you will find at page 825 of the bundle. And you will see over the page of 826, the operative part of the order that we sought. You have already granted paragraph 1, which is the collateral use permission. And so what we are asking for is paragraphs 2, 3, and then 4 is the cost.
Yes. Yes.
And that is all that I was going to. Oh, and I've been reminded, which I should have said it before, you may recall that the draft order does not include a penal notice. But your Honour was persuaded that in relation to Byju Raveendran, it was appropriate to issue an order with a penal notice on it. So I would ask you if you are minded to accept this application.
That was the draft order in relation to, the order in relation for the further disclosure.
Correct.
Yes, yes, I see, yes.
So in relation to the further disclosure sought against these other 2 defendants, we would ask that the order includes a penal notice, and I apologise that wasn't in the draft.
No, I understand.
And that was all I had to say, unless there's anything you would like me to deal with.
Just checking my list, I think you've covered it all. Yes, thank you. No, I don't have any questions for you, so thank you. It'll come as no great surprise to tell you that I will reserve my decision, and I will get it to you as soon as I can.
Thank you very much.
Well, I thank you and those assisting you and the court staff, and thank you. That completes today's hearing.
Thank you. Bye-bye.